It is wrongly listed in motion column. Your lordship was pleased to issue notice on the last occasion. Moreover, my lord, in item number 60, state has not filed affidavit. So may I pray your lordship may take up this matter after vacation, my lord. In the meantime, they will file their affidavit. Or
Who's for the state?
my lord, my senior
Who do item?
60 and 61. Implement.
All right, 6061 to be listed after 3 weeks.
My
The month of July. Not date meeting. The for admission respondents may file their affidavit with item.
interim order may kindly be continued.
Interim order passed earlier will continue.
Deeply obliged.
My lord, these matters may be listed. My lord, one is for motion and the other two matters are for admission, urgent matters.
What?
One is, my lord, regarding the, there's in this case, we have challenged the notice of the municipal board, my lord, whereby the construction has been stopped, my lord.
When?
This is motion, my lord. It was filed on,
5 matters. Structured matter. I'm taking up bench 3.
yes, my lord, bench 3 matter.
How is the service matter?
No, my lord, not service matter. These two matters are, my lord, bench 3 matters.
What are these?
One is compassionate appointment under this covered case, revenue department.
Yeah, and the other?
And the other one, this is regarding non-payment of bill, my lord.
Non-payment of bill again, bench 4 or bench 5.
Bench. Then only one, my lord.
Have
My lord.
to take them.
My lord, I'm praying for item number 64, my lord. Instructions are awaited on this. On the last occasion, instructions are sought for.
64 who's for the respondent?
We are for the respondents, my lord. We have taken consent of Mr. A. Chetri. The instructions are awaited, my lord. That is what.
64 adjourned for 4 weeks at the prayer made on by Mr. M. Sharma, appearing both the respondent number
All the respondents, my lord, 1, 2, 3, 4.
1, 2, 3, 4. It is submitted that consent of the council for the petitioner has been obtained. It's after board.
Issue by recommendation for listing, my lord. Matter regarding the minimum pay scale, my lord. The
Minimum pay scale.
minimum pay scale. Two liquidation matters.
2 writ petition.
Mostly.
Next week, some date, court must be given.
May I please, your lordship? Yes. In this matter, government taken 2 weeks time for instruction and they have not been listed. That way, next week.
So what is the subject matter?
Subject matter is that retirement benefit has not been.
Yes.
Fourth, my lord, 4 or 6.
May I please, your lordship?
Yes.
Your lordship, I'm trying for listing of admission matter, your lordship. Matter pertains to family pension, your lordship.
Family.
Obliged.
Second
Next week.
Second week of June. Yes.
Yes.
Second week of June.
Obliged.
Please, Lord. Praying for listing of two matters, Lordship. One is for a hearing, Lordship, termination of service.
Hearing matter.
Lordship.
Hearing, it can be listed for hearing. Let
Lordship.
it be for orders. Let it be for orders.
Yes, Lordship. Then, Lordship.
We'll fix a date thereafter.
Lordship. Two matters are there. One is for orders, Lordship.
Orders. What is the subject matter?
Subject matter, Lordship, he was recommended and Lordship for compassion appointment. And due to Lordship, his pendency of
Both
this
matter.
case.
Both matter.
No, Lordship, one. One is
The
for
other?
termination of service. Other is for Lordship, he was recommended for appointment in compassion ground.
Okay.
But because of pendency of this case,
So let it be in the second week of
Lordship.
June. Second week of June on a date to be fixed by the day. Yes.
May I please, your lordship? With due consent of the other side, I beg to mention item number 30 of today's list. The arguing counsel, Mr. N.J. Gogoi, he is unwell today.
Item 30.
30.
Item 30 stands paper to be listed after 4 weeks. As from the mention made on behalf of the council.
Lordship, I beg to mention item number 57 and 58, Lordship. On behalf of Mr. P. Kudatram. Lordship, these matter may be listed after 1 week.
50, 50.
57 and 58, Lordship.
You are making one mention on behalf of.
Mr. Bhuku, 3 petitioner.
Have you informed the other side?
Yes, sir. Comment.
Huh?
Comment.
57, 58. You are making a mention on behalf of the petitioner.
Yes, sir.
57, 58 stands paper to be listed after 4 weeks.
May I please, your lordship, item number 66, lordship, matter. Item number 66, lordship. This matter is infectious, lordship.
Item 66.
Lordship.
on a submission made by the council to the petitioner that the item 66 has been instructed. The recruitment does not wish to press the recruitment any further. The petition stands dismissed as instructed. Report is authenticated pending either.
Much.
Open item 1.
My lord, the last order, my lord, is directed to apprise by way of in chart, my lord, as to what is the exact amount to be recovered. My lord, the instruction received by department, my lord, given by the department is that, my lord, no work was performed by the contractor. Page 126, if my lord will take, that there is a chart, my lord, which where we have calculated.
Why have you filed this matter for
My lord,
appointment of an arbitrator?
yes, department is, my lord, claiming the risk and cost amount
Right.
from the contractor.
We have not issued notice.
Yes, not issue.
But step of response by registered post ID to the criminal court, it must be complete. It is-
Obliged.
but, appreciate it. It has been support week, steps on the reported by the criminal ID, the repeated after reasonable date. I would take a like it is the order.
Obliged.
Please.
Quick notice, return of report. Separate report. By
Obliged.
notice, 4 weeks of the attempts by related. Instead of
Obliged, my lord.
Five.
Obliged.
6. Item 6.
yes, who's appearing for item 6? Mr. Burwa? You're not present matter.
Page 10.
Agreed by the willful disobedience. Right? Should notice that in 4 weeks. Steps on respondent within 1 week. I read that it's after.
Item 7. Eight.
Lord, this pertains to non-consideration of promotion. My lord, I was communicated the reason, my lord, on 2nd May 2025 at page 17.
Notice, will
My
you-
lord, it's a case of.
Agreed by is not.
Oh,
The next high post. What is the next high post?
Naib Subedar.
Night together. Slash. Generally. Additionally. He guy. It is on behalf of all the respondents.
Yes.
The way back the public furnished within a period of 1 week. They responded. Their instructed file. In the meantime.
Item 9.
Not item 9 is against the order of dismissal. The
Judicial.
issue, my lord, but then the issue is that my appeal is still pending, my lord. They ought to have actually considered it because otherwise factual aspects, it's
Then you
difficult
get-
for the High Court
You
also,
Get instructions here, find out what is the status of the appeal.
my lord. Or if otherwise it can be disposed of, my lord, if it's not disposed of, my lord, this appeal should be considered, my lord, firstly.
So, but that's why we want to
My
know
lord.
what is the
Well,
status of,
my
when was the appeal filed?
My lord, it was in 2023, 14 November 2023.
14 November
2023.
It's been disposed of by now.
We have not been communicated any result, my lord.
Please get your instructions, let it come after 1 week,
My lord.
second week of petitioner. Petitioner was terminated from service. By orders passed by the disciplinary authority against same order, he had prepared and beat. The year, however, they defeat. For my body. It remain pending and no order that is passed. The agreed against the Procedural court, questioning the proceedings, questioning the disciplinary proceeding, dismissal of parts. There are, in view of the state that an appeal against dismissal order has been filed by the petition, let the CPC obtain instructed the status of the appeal by stated to an and to be listed against 13 June,
Obliged.
extra copies be furnished. The learned 60 of the furnished. That is on 13 June.
Item 10.
Yes, please. My lord, in this writ petition, my lord, we have challenged the, my lord, clause 15 of the advertisement that your lordship will find.
You are not selected.
My lord, we have got, my lord, marks, my lord, we have narrated, my lord, in the, my lord, petition that lordship will find at page 9. Page 9, my lord. We have given the marks, my lord, 93, so and so, so and so, so and so. Now, lordship, kindly see page 41, the cutoff mark fixed by the respondent authorities. Page 41.
41.
41. My lord, South Salmara. It is district wise, my lord. South Salmara lordship will find. PD 31, South Salmara.
Yeah.
Lordship will find right hand side column, my lord, OBC, MOBC. Here, my lord, cutoff mark is given, my lord, 102.30 for OBC and MOBC. It is male. Then, my lord, female, my lord, 70. And, my lord, OBC, we are not concerned. Then, last column, lordship only home guards and VDP. There is no, my lord, cutoff marks. So, if we see the, my lord, marks, my lord, cutoff mark 102.30 in the category of OBC, MOBC, then, my lord, the petition number 5, 6, 7, 8 and 9.
You are
Are-
applying for what? Home guard.
Not, we are for the post of Constable AB. Constable AB.
Then how is home guard
Home guards, there is one candidate for the post of home guard also. No, my lord, home guards means, my lord, those person working in the category of home guards, they would be, my lord, given preference, 1%. So the, my lord, the cutoff mark has been fixed.
No. All these petitioners are not appearing for home guard.
No,
How many are appearing?
my lord, we are appearing all the petitioners, 9 petitioners, my lord, for the post of constable AB.
AB. So what is your problem here?
My problem is, my lord, lordship, kindly see, first, my lord, page 9.
Yes. Yes.
Page 9, my lord, first paragraph, my last part. We have marked given, my lord, in the oral viva was, all they have obtained the substantive, that is so and so, so and so, so and so mark. Now, lordship will find petition number
They are all OBC, MOBC.
OBC, MOBC.
Then
Lordship, kindly see the, my lord, page 41. The cutoff mark fees for the South Salmara Mankasa district. 102.
yes, you have shown us. So
Yes.
what?
So, my lord, petition number 4, 5, and 6, and 7, 8, 9, they got the, my lord, marks as maintained in the cutoff. But they have not called for in the oral interview. Similarly, the other petitioner who are in the category of, my lord, home guards, BDP and NCC, they are also.
They will have
Right.
to obtain instructions.
My lord.
My lord, this page 41, what is the authenticity of it? There is no signature at all. Who prepared it? I will obtain instruction.
It is downloaded from the, my lord, net. My lord.
You obtain
It
it.
is not a download.
Third,
Yes.
Mr. Review.
Net
Another by that agree that they have not been called for appearing in the Viva Voce examination in spite of obtaining mark. In spite of obtaining mark higher than the cutoff mark prescribed for the OBC, MOBC category for selection for the post of constable in AB selection. According to the some of the which other petitioner?
Now, petition number 1, 2, 3,
1, 2, 3,
and 4.
1, 2, 3, 4.
They are general category. Sorry, my lord, MOBC. My lord.
1, 2, 3, 4.
1, 2, 3, 4.
They have secured more than the cutoff mark prescribed
5 and 6.
OBC,
And 5 and 6, my lord, in the category of home guards.
respect of petition of 5 and 6.
Six,
Also,
7, 8, 9.
it is submitted that no cutoff mark prescribed. Consequently, there is no notwithstanding sufficient mark obtained by the petitioner. Mark obtained by them. They have not been called for. Viva Voce for the selection and home guards. Mr. Mrs. Gutial and an additional will obtain instructed in the in order to enable him to obtain let copy sufficient copies of the report will be furnished in a 3 working days. It will be thereafter listed after 2 weeks.
Obligation.
My lord, item number 60, 61 is wrongly mentioned as a my lord motion column, but there is the interim order, my lord, this is just modified senior state, my lord. Yeah, instead of after vacation, my lord, maybe.
Maybe after 2 weeks, we have not been
You
informed.
mentioned it before, you called
I will inform.
call the council for the petitioner,
They mentioned and Lordship has passed fix the matter after the vacation.
right?
Well, let it be adjourned, but after 2 weeks if possible.
And you mentioned it before the
I-
council for the petitioner.
Lordship.
Go ahead.
They have not informed us.
You bring him, we'll, if both parties agree, we'll change it.
May I please, your lordship? Your lordship is a covered matter, your lordship. Matter
Covered.
pertains to compulsory appointment. Matter is pending before the SLC, your lordship, recommended by DLC.
Hmm.
Covered by the coordinate bench judgment, your lordship.
When did you file it?
It was filed after the due date, but it was considered in that case, your lordship, which I have supplied, your
So
lordship.
consider,
Yes, your lordship.
it was filed on 20 May.
It was filed
19/5/2025.
Yes,
and the judgment I have supplied, which was filed on 17/5/25, your lordship.
You get instructions, have it next
Yes,
week,
yes, sir.
find out. List again on Wednesday. Enabling Mr. Surya, Government Advocate. Read instructions and apprise the court whether the writ petition can be disposed of in terms of the order dated with submitted that down. Next of Wednesday.
On 4th, your
I am for 2, 3 and 5 only, but
We are not issuing notice. We are asking you to go through the order and apprise the court of it.
Item 12,
over there.
But this is seeking coverage under the old pension scheme. The law is otherwise settled as of now that people whose recruitment process
issue
starts.
notice here.
Fine.
But should be partnered with claim benefit of the old pension. Children are serving under various units. In various units under the Assam. Week. By all the respondents, so this is the way that will be the one. But they complete that file. The applicant. Extra copies of the report shall be furnished within 1 week.
It's for that one.
Obliged.
Obliged.
Matter pertains to the dismissal from service. This notice may be
Dismissal from service. No appeal.
appeal also, my lord, dismiss, my lord.
Party. Yeah, party. Serving I am slash DD. Under the SS. Proceeding. Disciplinary authority. The departmental appeal preferred by the negated the president. The destroy if responded with their with the may file their affidavit.
Obliged.
Well, my friend appears for the petitioner in that case.
Yes,
After 2 weeks, he appears.
after 2 weeks, because that's the last week.
Well, on 13th of June. Or
2 weeks will not be over on 30. It will have to be week thereafter.
16 or 18.
20.
Lodge.
20.
Lodge.
Obliged. Which are the items?
60 and 61 supplement.
61, we listed on 20.
Lordship.
Like 20. Yes,
14.
May I please, my lord? In this case, petitioner has been dismissed from service. So at this case, my lord, notice may be issued against the respondent.
what about appeal? Have you filed an appeal before the departmental authority?
No, my lord, there is no provision for appeal, my lord.
So
Once
is
the
the employee of a cooperative society or
Cooperative.
cooperative society, my lord, that is,
There is no appeal.
there is no appeal provision, my lord.
otherwise, your lordship, if we go by recessor name of your lordship, the petition is not maintainable.
That's right.
So far as the dismissal of service, the repetition is always maintained, my lord.
No, you go through that earlier judgment.
So that's when it is.
You give him the citation.
Lordship.
We'll
Keep
keep
you-
it for next week.
Yes, my lord.
Go to the judgment and address
Yes,
the
my
court.
lord. If there is any judgment, then my lord, that has to be followed.
That's right.
Deeply
So
obliged.
we are giving you an opportunity to go to the judgment.
Yes, ma'am. Deeply obliged, my lord.
That will be listed next week.
Okay.
Right.
I request me to the count.
15.
Matter relates to discharge from service, my lord. On the basis of a complaint made by the employee of the department, my lord.
You
And,
want file an appeal? Why have you not filed an appeal?
my lord, he has filed one, my lord,
You filed an appeal. There is a departmental appeal.
departmental appeal, my lord.
Go and file it.
Yes, my lord, an observation may be given, my.
Petitioner before this court is assailing the discharge from service by the bank authorities. Petitioner was employed as, what was he working as?
He was working as the
Loan sanction
loan sanctioning officer, Nelly branch.
in the Nelly branch. It was unbanked. Few allegations made against him for sexual harassment of domestic health. Proceedings were initiated and subsequently charged. On appointed very the court, counsel for the petition submitted that there is an appellate provision and if liberty is granted, she would like to raise the same. According to the petition, dismissed from the court. With liberty, to prepare the departmental appeal. Needless to say, if the counsel subsists, the that liberty to approach this court again after any such appellate order.
Okay.
16.
Please, Lord. My lord, recently, my lord, state government has passed, my lord, one notification. My lord, doing away with the scheme of compassionate
Compassionate.
secondment. My lord.
Compassion.
Yes, thereafter, my lord, some, my lord, aggrieved person approached before this honorable court, my lord. And there is a, my lord, bunch of petition. And this honorable court, with the consent of the, my lord, government side, my lord, give, my lord, leave, my lord, that to consider the, my lord, case on merit, my lord. Thereafter, my lord, accordingly, my lord, subsequently also, my lord, some
You are
petition.
telling the.
Yes, so formally I have also telling, my lord, ultimately, my lord, we are, my lord, paying leave to consider on merit, my lord, as per the judgment of this honorable court, my lord.
Yes, responded.
Yes, but see, whether he is considered, he may be considered by SLC lordship.
My lord,
Otherwise-
Miller order, my lord, recently, my lord, passed by the court number 5 also, my lord, to consider by the SL.
You can tell it to the notification.
Yes, my lord, but government side, my lord, agreed to, my lord, consider, my lord, the, my lord, matter on merit,
Why
my
don't
lord.
you go through the order again and
No,
advise the court?
No, yeah, no lordship, In this matter that his case was pending on SLC.
SLP. Therefore, my lord.
But here,
Same matter, my lord, serial number, his name is, my lord,
otherwise,
serial number
You-
10.
You consider, you go to the order,
Yes.
examine the matter, we'll take it up next week.
yes, Lordship.
We'll have it on Wednesday,
My lord, lordship kindly will
Otherwise,
just, my lord,
kindly see page number 55, Lordship.
55.
Yes, Lord. Para 10. Order of the,
55.
yes, Lordship.
Yeah.
Para 10. And the last line.
Yes.
It is again made clear that this order cannot be used as a precedent for cases that are filed on 4/4/25 and thereafter. It shall only apply to cases that are pending before this court as on 3/4/25.
Hmm.
And we file this case today, Lord.
accordingly, my lord, this is also one of the similar order, my lord. Even thereafter, my lord, next paragraph, my lord. Important, my lord, paragraph 5, my lord.
So if this matter is to be disposed of in terms of the first order,
Yes.
consent order,
Yes.
then the entire
Well,
order,
even then, thereafter also, my lord, government has,
then if you are relying on that order, that this condition has to be satisfied that it is that the writ petition was pending in the court
yes, my lord.
till so and so date.
Even, my lord, therefore I am submitting, my lord. Even subsequently, those petitions are filed, my lord, also similar order is filed.
I
Lordship
think
kindly have a look,
at this stage.
lordship kindly have a
No,
look,
no,
page,
I
my
am
lord.
not covered. I am not present.
My lordship kindly just, my lord, I am from the record on page 39, my lord, serial number.
There is a notification issued by the state
Yes, my lord.
that becomes a law unless interfered with, set aside, withdrawn. Can this court issue a direction to consider cases, divorce the notification without interfering with the
My lord,
notification?
this is right, my lord. But only thing is that, my lord,
If this is right, your petition is wrong, we dismiss it.
no, no, lordship, subsequently also, my lord, government side, same concept is given because they cannot, my lord, some people will consider on merit and some will not consider. Therefore, subsequently also
They
they
are not consenting now.
consenting, my lord. Lordship kindly will look, this is the order.
In your matter. In this matter, they are not expressing consent here. They are not giving a consent.
But in the, my lord, lordship, therefore, my lord, page, my lord, 39, serial number 26, my lord, regarding and my serial number 28, my lord.
Are you saying that in one matter they have given a consent, it is a binding precedent for all matters?
Yes, my lord,
Right.
they are, my lord, lordship, therefore, lordship, kindly will look, my lord, page 39, my lord. Page,
Right, heard. We are dismissing your petition, we are passing an order. On the ground that you are not pressing the further prayers for challenge to the notification.
I am challenging, my lord. Formally, I am challenging in this petition also, my lord.
So challenging is all right. Are you pressing the challenge?
Yes, my lord.
You are.
Yes, my lord.
Heard at council. Parties issue notice. Respondents may file a very happy. Petitioner challenge the notification dated 40, what is that? 14/9.
Yes, my, yes.
What is the notification?
Notification dated, my lord, 18.
18/9/2024, whereby the government of Assam has taken a policy decision that there shall be no further consideration of appointments on compassionate ground. This said notification is valid in the present proceeding. Placed after the return of MS as Borwa appears for
1, 3, 4, 5, and 6.
1, 3, 4, 5, and 6. Mr.
B. Talukdar
for
for elementary education department.
elements. Since the respondents are represented, the way be furnished within 1 week. We are issuing notice on your challenge.
Page 52 is the impugn order, lordship, termination order, lordship. The petitioner was working as a professional. the time of, during his probation period, Lordship, he was terminated on the ground of providing false information regarding the domicile certificate, Lordship.
You are not confirmed.
Not confirmed. His probation period was extended, Lordship, and thereafter he was terminated, Lordship. I have filed also an appeal also, Lordship, which is pending, Lordship.
What is the status of the appeal?
I have to obtain.
Heard? The actual- Where is the termination order?
Page 52, Lordship, annexure 5.
Dated 19/3/2025, where the petitioner was working, was serving as constable G, CISF on probation. Where is your appointment order?
Annexure, Lordship. Annexure 4, page 49. $11,000.
Where the petitioner serving was provisionally appointed and was serving as constable CISF. He agreed he had prepared an appeal for the departmental level authority. However, state appeal has remained pending, has been pending. For his level passed. The agreement Mr. destroyed obtain instruction that status of the appeal stated to. Do you have any date which the appeal was filed?
Lordship, it is on 12/4/2025. It was sent to Lordship, registered post, Lordship, and it was received on 16th of April 2025.
Filed with the petitioner. Appeal was preferred by the petitioner in April 2025. Mr. H.S. Roy be furnished with sufficient extra copies. Complete instruction. Still on 13.
Lordship. Lordship.
Obliged.
Lordship, let it be on 17th.
17.
Lordship.
18.
Lordship.
19.
May it please, your lordship. My lord, we are presently serving as the junior administrative assistant under the Assam Agricultural University. And our grievance is this, my lord, although we have the qualified service for promotion to the next higher post of senior administrative assistant, my lord, we have not been considered for the promotion. And in fact, my lord, 28 numbers of junior incumbents have already been promoted. So we have the qualifying service, my lord, and in fact, my page 90 is the gradation list, wherein our name placed at serial number 1 and 2. Page 90 of my writ petition. Serial number 1 is the petition number 2, and the serial number 2 is the petition number 1, page 90. It is the final gradation list of the junior administrative assistant. And in spite of this, my lord,
Petitioner number 1 is?
petition number 1 is serial number 2, Supanya Goswami. And petition number 2, Pronita Deka, is at serial number 1.
Serial number 1. Then is the
Thereafter,
gradation list.
my lord.
Is the final gradation list?
Yes, my lord.
May I something? If my lord, where is my lord? I'll take instruction. Apparently, my lord, something is wrong because my lord may see the serial number 3, Midul Tamuli.
Serial number 1.
Serial number 3, my lord, will see Midul Tamuli. Apparently, junior than the 1 and 2.
No. You are referring to which page?
Same page 90, my lord.
90.
Let me talk with the university, my lord. If something is wrong, my lord, I'll ask them to correct it, my lord. Serial number 3, my lord, will see Midul Tamuli. Page 90.
Page 90.
Middle Taluka,
Yes.
Tamuli.
Tamuli.
Ah.
And if my lord now perishes 95, my lord, the order by which they were promoted. Middle Tamuli has been promoted, but petitioners are not promoted. my lord. Currently, my lord, the region that appears to be is that, my lord. The petitioners were earlier serving at my lord,
At Priti Vigyan
Vigyan
Kendra.
Kendra. Perhaps, my lord, that period has not been
Has
taken
been
note of. That has not been taken note of. My lord, we'll fix it on 12th of June, my lord. I'll take instruction, I'll talk to the industry, my lord. If something is wrong, we'll correct it.
Petitioners of this court. Not consideration for promotion, the next higher post of senior administrative assistant. Petitioner the presently serving as junior administrative assistant. The Assam Agricultural University.
Right.
Referring to the final gradation. Pardon. Prevent spike of cases have been followed. They are not considered. Swami Learner Council presenting the university. You're for the university.
University, 1, 2, and 3.
Let's pray that the mathematics is sitting in on
12th of June.
12th of June. I will take prayer date is not objected to by the council. Yes. Item. Extra copies. Be furnished.
Yes.
Study council. Enable appropriate instruction.
Okay.
Development.
Election of Gaon Pradhan, selection and appointment. This one prepare appeal, which is pending before the.
Yes, appeal pending.
Whether the appeal has been numbered or not,
You get your instructions, please.
Lot.
Let him get his instructions on Wednesday.
Yes.
Well, no. Hey, I got-
Oh.
They- Yes, can you get it on Wednesday?
Lordship, I will try lordship. Only number lordship. If number is the appeal has been numbered, then
You get the information whether it is numbered, if not, why not numbered? If numbered, whether any orders are passed.
Lord. 3 times transpired.
Huh?
Initially, it was before the
That
divisional commission.
So it must have been numbered, otherwise how will it be done?
It is difficult to proceed to.
So we then take it about 13th, 13th.
Lordship.
Getting to the review. It's never that. Here for the selection process for appointment of town president. But district for the district under the district of Disciplinary. By the selectly stated one level by our board was appointed. The appeal prepared stated to have been status of the stated to have the next day fixed. 13 extra copy be furnished within the course of the day.
Lordship, I am appearing for response number 3. Lord, deeply up.
21.
Lordship, kindly pass over this matter for time being. Kindly pass over this matter for time being. Opinion is lagging another way.
Time being. Time being.
22.
Yes.
Please also, my lord, petitioner is a BSF constable, my lord. So he is specified as GSF trial, my lord. Accordingly, my lord, is punished and dismissed for service, my lord. Against that order, we made my lord statutory appeal that has been rejected, my lord. So petition filed challenging those, my lord, impugn order, my lord, and rejection order, my lord.
Mr. M. Saronial, let it come. The order. Which is the order, impugned order, dated?
Impugn order, my lord, 8-1. No, he said. Thirteen 3/2025, my lord. Page 72, annexure 11.
Special order passed by the disciplinary authority as well as ordered by the departmental appellate body whereby dismissal was updated. Yes. Right. But then from the responsible. Responded, they complete their instructions by the
The interim prayer, my lord, to suspend the impugn order and allow me to go on bail.
dismissal.
You are already to consider for the next eternal date, my
Struck
lord.
off from the roll.
Yes. My lord,
You are struck off from the rolls, even if it's suspended,
my lord,
because striking off from the rolls means all the pay, wages, whatever.
my lord. That is stuck of my lord. My lord, the impugn order, my lord, 9/10/2003 also, my lord. It will be, my lord, as a impugn order. My lord.
We are saying that dismissal order by the disciplinary authority and the
My
appellate
lord.
order.
No, no, no. In case of disciplinary order, my lord, dismissal order, my lord, they have not communicated. That's why I could not, my lord, annex. But order is, my lord, 9/10/2023, my lord.
We have indicated in the order.
My lord, the proceeding may be also, my lord, more learned to produce the report, my lord, GSF proceeding, my lord.
First, let him file the counter if they want to. If we call for the records, how will they file the counter?
My lord.
Let them file it, and if the whatever records are necessary, we'll call for it.
My lord.
23.
Please, my lord. My lord, in this case, my lord, I am seeking incremental benefit, my lord, from my date of initial appointment, my lord, and the past service has not been counted in computing family pension and other retirement benefits, my lord. That is the main case.
We'll issue notice that it's required. Yes. You are appearing for all.
I'm present 1 and 2 and 5, Your
Respondents 2 and 5.
I am for 3,
2
Lord.
and 5.
I am for 3.
As Purva for 3. Yes, take Purva for 1. Who's for 1? PWD. Mr. B. Chaudhary for 1. Who's for 2? 2 and 5.
2 and 5, irrigation department.
No. 3 as Purva. Then 4 and 8. It's H Purva. And accountant general, Mr. R.K. Dalwai. The respondent represented. This is the way.
Obliged.
24.
My lord, though he was eventually promoted in April 2024, my lord, he had sought for fixation of his seniority at par with his juniors, my lord. That has been turned down, my lord.
Petitioner before the court is serving as the type to that. Yeah, some right. He has not been promoted.
In 24, he got promoted, my lord. Then he is now seeking, my lord, fixation of his seniority with, at par with his junior.
Promoted. The expired post of Subedar. He's Subedar or?
He's Subedar, I think.
He's Subedar. His seniority with, his seniority, vis-a-vis his peers were earlier promoted. Has not been promoted. He has
All the
the response. It's after the
Obliged.
25.
appear. Study would be appear to the market. And would be-
Obliged.
26.
Wait, please, your lordship. In this matter, we are challenging the censure, order of punishment, minor punishment of censure, as well as your lordship with regard to his seniority and the promotion from the day when his juniors have been promoted. These are the broad parameters on which we have come before this.
No appeal. No appeal was filed.
Appeal was filed. Appeal was converted to censure. But this was a period of about 4 years he was kept taking. Now the promotion is given with prospective effect because that is where I have come.
The petitioner was a retrospective effect of promotion, my lord. Because retrospective effect of promotion, the petitioner one. My lord, may issue notice that this is
Yes.
And it's only for seniority. You are asking for the seniority.
Seniority and the lordship retrospective promotion. And also challenge the censure. In fact, we are challenging the censure.
Think to carry the penalty
not
of
fair.
censure. So if will it benefit of proportion,
Order
if
to
it-
conduct reaction being applied.
that's fine. It should put it. Then for the respondent. Okay. Okay. After 4 weeks, after it.
Much obliged.
Keep your pleasure.
Yeah, item 29, my lord, just your lordship has called. Item 25. If possible, my lord.
The court master, he'll call it whenever he is there. Yeah.
This matter relates to compassionate appointment, my lord. My father, Mohendra Soikia, while serving as
Are you putting a challenge to that notification?
yes, my lord. I have challenged, my lord.
You challenge.
Yes, my lord. Page 36. Dispose of, my lord. Similar matter has been disposed of, my lord.
No, not similar.
It is clearly stated in the WPC number, not
Not similar.
That-
If you want, we can issue notice to consider your challenge to the notification.
My lord, page 41. Similar issue, my lord. Chain, my lord. That was also filed after 3/4/2020.
All right, you examine the matter.
No.
Take it up next.
Obliged.
Third. Council reports raised topics that the order dated when so fast with the but relied upon the we'll have to take that skip the other. And it will be- Okay. And I just think-
But the matter was listed on 28th, and I prayed for some interim relief, but the court said, let him go through it and find it out in the inquiry report, whether they can substantiate whatever the allegation that we left. Because if you see, substantiate the allegation which has been leveled, because I retired, in 2022 I retired. I was the deputy commissioner, lead and deputy commissioner of one district. But there are three basic allegations. One is that I have taken a leave. That was not sanctioned, 1 day leave. And that has been justified. Second, there is another charge which has been leveled that when I was the deputy commissioner, a land acquisition proceeding was initiated. But all this proceeding which was initiated up to law, the conclusion that the money has to be paid, this was done by deed and deputy commissioner. Only, my lord, the amount was released. Now, third is that the procedure of land acquisition was not followed. These are the three basic charges which are leveled. Reply has been given, but what was the main contention when the SOCOS was, my lord, served?
Proceeding is still under.
No, it's over. Proceeding is over. I got provisional pension. Enquiry report was furnished, which was against me. Thereafter, my lord, and this was sent to disciplinary authority, uphold the enquiry report, which was which was by the enquiry officer. Now, my lord, if you see the impugn order, not a single reasoning is there. What is the reasoning?
Did you file an appeal?
No, I filed this repetition before this honorable court. No, that is a repetition which has been filed before this authority. We have filed the repetition before the authority.
But no appeal.
Repetition has been filed.
Why was
At page 295 is a notification.
95?
The order has passed by the governor because you have to prefer to a governor. That's the reason, man. Order passed by the governor at page 295. My notification. So 21st of February 2025. Mine is a one page. There is no reasoning, no application of mine. Why this enquiry report that he said that, okay, fine, this is what I have accepted. Now my case is that, yes, your lordship will issue a notice in this case. But I was.
This is an order under 21.
Yes, correct. Right, correct. But what I am praying that pending departmental inquiry also I was receiving provisional pension. Now, once this finding, then this order has been passed, I have been stopped, and they said that your entire pension benefit, we are permanently withholding your benefits. That's I'm agreed. If you see 22, my lord, of the Assam Service Pension Rules.
Pension. Yes.
Rule 22, where any departmental or judicial proceeding is instituted under Rule 21. Don't you got it? 22.
Yes.
Where any departmental or judicial proceeding is instituted under Rule 21, or where a departmental proceeding is continued under Clause A, provided thereto against any officer retiring on attaining the age of compulsory retirement or otherwise, he shall be paid during the period commencing from date of his retirement to the date on which, upon conclusion of such proceeding, final order passed, a provisional pension not exceeding the maximum pension which would have been admissible on the basis of his qualifying service up to the date of retirement, or if he is under suspension on the date of retirement, upon the date immediately preceding the date on which he was placed under suspension, but no gratuity or death cum retirement gratuity shall be paid until the conclusion of such proceeding and issue of final orders thereon. Payment of so and so order shall be adjusted against the final retirement. Now the question here is, my lord, the departmental proceeding which was initiated, did and at that relevant time. So I was getting, now I am aggrieved by the inquiry which has been conducted and they have come to a conclusion. Now a judicial proceeding against that is pending for this court. Or a judicial proceeding against that order that has been passed. So what I am praying, my lord, at least for my sustenance, they should pay my provisional pension and your lordship will decide the outcome. And second is important.
There's a very clear finding in the order.
What I'm saying, court wanted to see whether this, the inquiry which was initiated, my lord, whether that has been substantiated by the order that has been passed. What are the allegations? Whether it has been proved.
Let me examine.
No, that's what I.
When there is a order already passed by the governor. That
I've seen that. Yes. Correct.
may not be for us. Because that will amount to
Giving a
that order.
Your lordship is not giving a final order. Giving a provisional pension is not a final order. Ultimately, the intent of the
Provisional pension is when the matter is under consideration.
but
once
we
the final-
kindly see there are two things. One is departmental or judicial proceeding. Departmental or judicial proceeding.
That will have to be examined.
Correct, my lord.
Whether it was
But-
4
but-
years
but-
or after 4
My
years.
lord, that's when a departmental proceeding is not being initiated and is continuing. Even then, the employee is not restrained from giving that provisional pension, my lord.
No, it is not. But if you
Yes,
see
that's what I am.
21.
That was the court was, my lord, putting a question to my learned friend that whether it can be
See,
justified. Prima facie, yeah.
21 gives the right only to the governor.
I'm sorry?
21 gives the right to the governor.
Yes.
It is very clear that the right is for withholding or withdrawing a pension. So when the process is on, yes, you may be entitled to provisional pension. But the order has been passed saying
No,
that the
see, there are, my lord, this 22 has to be interpreted whether a departmental proceeding. So, let's see the wording of the 22, my lord.
Yes.
Where any departmental or judicial proceeding is instituted under Rule 21, or where a departmental proceeding continued under Clause A of the proviso thereto against any officer who retired on attaining the age of compulsory retirement or otherwise, he shall be paid during the period commencing from the date of his retirement to the date upon which conclusion of the proceedings, final orders are passed, a provisional pension not exceeding the maximum pension which would have been admissible.
We'll have prayers open, but at this stage.
No, let it be like this, my lord will fix it a date. Let a notice be issued for next for passing of an interim order. Will fix on a date. I'll try to look over any judgment on 22. What do you mean by department and judicial proceeding? I will look into.
No, you are praying for a
provisional pension.
Provisional pension.
Yes.
Notwithstanding an order having been passed after 21. Order has been passed. You are putting a challenge.
Yes,
we
right.
are looking into the correctness of this order.
Correct, right,
There's
absolutely.
no, that is on a separate
My
department.
lord, will kindly see for a moment. I'm troubling your lordship with this impugn order. Please look into the impugn order.
Yeah.
Prima facie, see the impugn order at page 295. 295. Lordship got it?
Yes.
21st of February. whereas so and so submitted inquiry report, first, second, third, fourth line, fifth. Fifth, whereas inquiry report was examined. Lordship got it?
Yes.
And accepted by discipline authority. Copy of inquiry report was submitted to DO by letter dated seeking his representation on the inquiry report, if any. Whereas so and so, that is the petitioner, by this letter dated 22/2/2023, submitted his representation on the report of inquiry, and the same was examined in conjunction with the materials on record and found devoid of any fresh convincing ground that what has been adduced in his written statement in defense already on record, and the same was found to be unacceptable. And whereas, considering facts and circumstances, it has been decided by disciplinary authority to inflict a penalty of permanently withholding pension, including gratuity in full, with reference to Rule 21, Rule 9 of so and so. Whereas so and so has been constituted a proposed penalty this department endorsement dated so and so agreed to propose penalty of permanently withholding pension including gratuity in full with reference to 21 and Rule 9 of the Assam Service Pension Rules 1969, so and so and. Rule 9 to Rule 9.
Oh, so that's what we are saying. The ultimately the order passed is permanently withholding.
But there is, my lord,
We will examine this.
no, correct, but there is no reasoning as such. You
Whatever
give
it
a
may be,
report, no, there is a report, you have to exercise your mind. You don't exercise your mind. Prima facie kindly see the order that has been passed
No, then
by
we
the
have to keep
discipline
this order
authority.
suspended. We are not inclined to do that. There is
I'm
a
sorry?
reason that we'll have to keep this order suspended. The operation of this order suspended. It's a very excessive right prescribed under the. But we are keeping your prayer for it to be open. Let them find their response. Reconsider. But that's for us.
Yes.
Before this court. 21st of February. This is the only order you're challenging?
I'm challenging this one, 295.
Whereby the penalty of permanently withholding pension in full with reference to 21 or 9 years after has been passed respect to imprisonment. And also departmental proceedings initiated ID show to the city accountant submits that the manner in which the department of the judicial very over and more particular the complete violation such circumstance. The order and challenge during pendency of the matter be considered under 21. The petitioner was receiving. You are receiving provisional pension earlier.
Earlier I was receiving.
Receiving provisional, which however it stopped the people superannuated service. When did you superannuate?
No, I superannuated in 2000, 31st of 31st 1 2022.
Graduated 31 therefore that the new order make valid.
One second, my lord. I'm sorry for disturbing in between. Rule 21, rule of the pension rules, and also Rule 9 of the Assam Service Disciplinary rules.
Yeah.
Rule 9.
And during the pendency, should be granted. He responded to that. Continue. Mr. Suti, anything to submit?
Yes, I have 1, 2, 3, and 4.
No, are you
4 weeks.
instruction? You are seeking time for instruction.
Instruction I have received, but instruction says that they are paying to apply this tribunal court at least 4 weeks time.
Mr. On
It's 1 of 5 men.
APSC.
Pilot.
Yes. 3 weeks. Who's respondent 6? By name.
By name.
Inquiry office.
By name.
Yeah.
So, 3 weeks. It might be. Very good. It might be. Considering the prayer break, reconsider. Have it on 20, not 19th? 19th?
19th June.
June?
Yeah. Okay.
No.
So,
24th. 24th June.
24th June. June take it on 26th last day. Or 27th. Last day, COVID was over and managed. Let them give a copy to us in advance so that any affidavit filed by them, they said that he received instruction. A copy.
They will provide me extra copies, madam. Only one extra copy was given, I was given to the only one.
Mr. Das is a very positive man.
I'm not about
He
They will
expects you
provide
to
my.
file an affidavit.
He didn't go yesterday, he gave it. Obligement.
At least have your instructors if you can't file your affidavit.
Yes, yes, madam.
I think instruction is not said a lot. Instruction is.
Instruction at this stage is to pray for 3 weeks.
Yes, 4 weeks time, madam. Okay.
That was not what the court was asking.
No, court was actually, but he says what is reason? Reason is given here, madam. Inquiry were made, approved.
Reason, 2-line reasons. I will satisfy.
May I pay all of this? On the last occasion, it was directed to obtain instruction. That matter relates to transfer. I'm taking retention of my transfer on the ground that my son is in the last stage. He is suffering from kidney disease, CKD. He needs regular dilation. This is my.
What is your instruction?
Yes, madam. On zero three,
Sorry?
on paragraph number 3, madam.
Yes.
As per circular number so and so, personnel have to serve 16 years out of home service during the entire service. In the instances, petitioner served for out of home sector tenure only 14 years, 1 month, 4 days. Hence, the petitioner was due for posting to out of home sector for annual transfer 2025 as per guideline of posting circular dated 7/24, dated 23/12/2024. As he has not completed out of home sector service of 16 years, thus the petitioner was given opportunity submit of 10 choice location excluding the home sector to the transfer him as per his choice location. Accordingly, the petitioner has submitted 10 choice, and then in the first choice we have given the transfer, my lord. That is his first choice, my lord.
Then why are you challenging the order?
My lord, what? My lord, my son is suffering from my lord kidney
Right,
disease.
but you are given choices.
But there is no facility. It is not that I am not complying the order of this higher authority. I am ready to comply, provided the medical facility may be available there.
You were given choices. Why did you give this choice if medical facility was not there?
I don't know, Mala. Let me copy a copy, Mala. I'll take an instruction from.
You get instructions. What copies you want? These are instructions to the council. You will not get copy of this. You're not supposed to get copies of this. Your client.
No, my lord, this is Murshidabad. I was transferred to Farid. Huh? Arakka.
Farakka.
Yes, my lord. Kindly see,
What is
my
the
lord.
impugned order?
My lord, impugned order is listed from page 17. My lord, my name is appear in page number 19. From top, my lord, is 5. 1, 2, 3, 4, 5, my lord. Serial number 5. H. Atamba Sharma from notice sector to notice to Calcutta FBP Kharakka, my lord. It is not the case that I am not ready to go. I am ready to go provided medical facility may be available. It is clearly stated in my petition.
So what is this?
Yes, my lord.
Next para, my lord. Subsequently, the petitioner has been allocated the Murshidabad, West Bengal, Calcutta as per choice of first cause filed by the petitioner and was earmarked to the CISF unit FPP Farakka by later dated so and so.
I have not understood. If he has been allotted Murshidabad, why is he posted in Farakka?
Subsequently, petitioner has been allocated the Murshidabad, my lord. Then filed by the petitioner and was earmarked to the CISF. That may be, my lord, that unit, my lord. I have to take instruction after some time, my lord. There's a Farakka and this the difference between Farakka and Murshidabad, my lord.
You go through your instructions properly.
Yes, my lord. After some time, my lord.
Monday.
My lord,
Have you really have you been released?
no, my lord, I have not been released, my lord.
The matter be listed again on Monday
My lord,
as the learned CGC seeks liberty to complete her instructions in the matter. So petitioner having made a statement after the petitioner having stated before the court that he is not
My lord.
released or the release order has not release order issued.
no, it's not issued, my lord.
Similar order has been passed by this honorable court, my lord. In the similar order, my lord. Kindly see this one, my lord. Still go. For same transfer order, my lord.
Are you at the stage of your retirement?
No, my lord, I am not in the stage of retirement.
But he has
My
filed
case
one.
is totally
He has
different,
filed
my lord.
another.
There are,
Which time?
yes, my lord, there are some instances.
Yes, my lord.
Address the court. Matter be listed on Monday. Till the next date fixed, transfer orders shall remain state.
Yes, my lord, deeply obliged, my lord.
Get your instruction.
Yes.
I think I think 17.
It is also similar, my like item number 25, my lord. Here is a covered judgment, my lord. When after filing of the requisition, after 3/4/2025, there are number of requisition has been disposed of, my lord. Page 42. On same issue, same, my lord.
Notice have to go, lordship. Notice have to go.
On Wednesday, the other matter has been picked on.
Be listed again on Wednesday as prayed for.
10.
Listing it on Wednesday. You get your instruction.
Witness it.
For orders attend 27 to 29.
Wait, please, your lordship.
Yeah.
Lord, this is a matter where a recruitment process was initiated by the Lord Government of Assam for filling up about 863 number of grade 3 and 4 posts. Now, initially, my lord, this task of recruitment was given to Assam Police Recruitment Board. Subsequently, my lord, that decision was done away with, and by the impugned order, this task of making this selection was given to Guwahati University. Now, my lord, we are on a slightly different engine. In this case, my lord, initially they adopted a system called digital Viva,
1 minute. You are seeking review of the order dated.
as well as one writ petition. Yes, my lord.
Now you are addressing on the review of the writ.
The same set of argument either for the review or for the writ petition. Now, my lord, my only submission is this digital Viva is more objective. What happens, my lord, in the screen, some
I mean, options come, you have to give one. Now, my lord, how when the government of India and state government has adopted a policy decision that in case of grade 4 appointment, there will be no interview. And when interview is the mode of selection, then a lot of question marks arise. Now, government of India, please come to those two decision of government of India, my lord, and Assam.
In the writ petition, you're referring to the writ petition.
My lord, same ground for both the writ petition and review.
So you're referring to which pages now?
I'm referring to the writ petition, my lord. 4017 of 21. A writ petition from the
4017, I can.
Yes.
29.
Lordship, should kindly come to page number 158. That's the office memorandum issued by Government of India.
Yeah.
It was on 13th of April 2017.
Yeah.
The undersigned is directed to refer to this department's OM dated so and so, by which recommendation of the committee of secretaries for discontinuation of interview for junior level post in the Government of India was conveyed to all central ministries department. Now, clarification has been sought by different department organizations whether the decision of discontinuation of interview is applicable to direct recruit only, or is it applicable to other modes of recruitment also. It is clarified that decision of discontinuation of interview in junior level posts in the government is applicable to all posts up to Group B, non-gazetted, irrespective of the mode of appointment, that is promotion, deputation, direct recruitment, etc. So this was the prescription by Government of India, Miller. And if Lordships turn over to the next page, that's by the state government. That is on 26th of May 2016. I am directed to say that the Honorable Prime Minister of India in his speech addressed to the nation on 15th August announced that process of holding interview for direct recruitment of junior level post, where personality assessment is not absolute necessary, requirements shall be discontinued. In this respect, Honorable Chief Minister has directed that system of holding interviews for recruitment of such posts, grade 3 and grade 4 posts, where personality assessment is not an absolute requirement, will be discontinued with immediate effect. You are therefore requested to examine, etc. So decision has been taken both by the Government of India as well as by the state of Assam. Now, my lord, this recruitment they want to make. In fact, I think the process has completed. No? But even then, my lord, as per our instruction, even post 153 posts are still there, which they have not filled up. And Lordship will kindly see when it comes to interview, what is how they would determine which component would carry how much mark. All subjectivity, my lord. And when there is the parent government, that is the Government of India as well as the state, has taken a policy decision to dispense with interview in direct recruitments, grade 3 and 4. How can the state, my lord, now again revert back to that? That is what is under challenge in the writ petition, my lord. And also in the review petition, where, my lord, our contention was rejected. It's an open action. Or Lordship can have it on a particular date for disposal, my lord. Today is a Friday, I can appreciate that. And they were also asked to bring the records from Guwahati University.
There's no affidavit filed, there's no date.
Yes. No, no.
For the respondent, what do you think?
Nobody has filed affidavit since 2021.
Lordship, we have the record, Lordship, and regarding affidavit, Lordship, we didn't have much role in the case.
Guwahati University is the agency through whom recruitment was made.
Where is Guwahati University?
No, the social justice.
Who's for Guwahati University?
PJ Fukon appears, my lord.
He is coming, Lordship.
Heard, Mr. We'll keep it for a hearing.
On a Tuesday or a Thursday, my lord.
Heard, Mr. K. Please, ma'am. The writ petition conducted and to hold the interview afresh for the purposes of election and appointment of grade 4 reserved for persons with medical needs in the department of legal. They take the guidance of participating president itself and the selected. This decision was taken after the selection had commenced, thereby the same as the same is contrary to the procedures prescribed and the rules, procedure and rules prescribed for tracking selection and appointment of persons for the post of counsel for which department?
Social justice.
Social justice. The records are here. Yes. That no affidavit is not filed, the records are available. Matter would require some hearing.
On 19th, my lord. Yes.
19th of June.
Deep level.
Review petition also be listed on 19th.
Deep level.
Regarding appointment of the petitioners, my lord. Regarding only petitioner number 2, 4, 10 and 13, they were not appointed, others are already appointed, my lord. So now regarding the appointment of these 4 petitioners, my lord, SSC already declared their result, my lord, all clear and given to the CRPF authority for do the further actions, my lord. Now CRPF authority written to the, my lord, concerned deputy commissioners regarding their PRC status, my lord, permanent resident status. That is clear, well, immediately they will be appointed, well.
So the results are declared in respect of all the petitioners.
All the earlier, well, others petitioners already appointed, except petitioner number 2, 4, 10 and 13. Their result also, well, declared, they were cleared, withheld cleared, and now the concerned authority is the CRPF.
Yes.
They wrote to the concerned deputy commissioners for the PRC status on 14/5. They'll be appointed immediately. I am appearing for
Writ petitioner. Which are the writ petitioners?
petitioner, no, contempt petitioners number, my lord, 2, 4, 10 and 13.
2,
4, 10 and 13.
2, 4, 10 and 13. Have also cleared the examination and
the results are earlier withheld, now withheld cleared.
as the results have already been declared, and the matter is that at the stage of verification of their certificate for PRC.
For PRC status, my lord,
which is required to be verified by the
concerned deputy.
Once the certificate, once the confirmation is received, the petitioners can be appointed with their respective. So the other petitioners have already been appointed.
All
be there for some that further 4 weeks time being granted, at which time it is expected that this exercise that this matter be listed again after 4 weeks.
Very good. So in this matter, my lord, I have filed an affidavit. One additional affidavit has been filed. That has not come available.
You have filed?
Yes.
Yes, Mr. Chakraborty, you have received.
I have received, my lord. Here, their contention is the same.
Let me come.
Let it.
Mr. Mr. Reza, additional affidavit has been filed. When?
Yes, sir.
Yes, sir. It's said affidavit not taken copies of the affidavit, additional affidavits, it is have been filed and connected to the case report. Well, it's not to be.
Obliged.
33.
My lord, I have filed a additional affidavit yesterday, my lord.
You have filed an additional affidavit.
Yes, a copy I received yesterday, Lord. It is but not in record.
Mr.
A. Burua.
A. Bolu.
A. Burua.
A. Bolu. The petitioner,
P. Hazarika. P. Hazarika.
P. Hazarika. Appearing for,
File respondent number 134.
appearing for the submit the initial affidavit and the file. You are appearing for all.
No, Lordship, for two I am appearing.
134.
Appearing for 1, 3, 1 and 3. Submitting an additional affidavit and file. So please verify and having the same. And it's the matter after 1 week. The date will be, I will respond after 1 week.
Obliged.
34.
Yeah, please. Lordship, here the case was a bit of whether a direction was given for granting minimum of the pay scale to the petitioner's lordship.
Yeah.
On the last date, we were informed that a proposal was sent to the finance department. Lordship, it is under process. Lordship, we seek 2 weeks time. In the meantime, Lordship, we will try to comply with the court order.
Mr. R. Madhukar, the date will be
Respondent number 2.
Pay. Respect to the in terms of the order. That direct consideration, the final plan. It prays for
2 weeks.
Week further time. To see for my court.
For respondent number 7.
Matter therefore be fixed after 3 weeks. By which time experience. Price report on the status of the respect of the
You pay for date.
date
Inconvenient.
20. 22.
I think 35 and 36.
In this case, my lord, on 21/5/2025, OSIF directed the petitioner to produce the order dated, my lord, 8/9/2014, person contempt case number 31 of 2008, my lord. But we have applied for the copy on the same day, but till that, my lord, copy has not been supplied. So, my lord, lordship may kindly arrange the registry to check the contempt petition along with the record. The application, my lord, we have submitted on the 21/5 itself.
But Mr. I, it's okay, let it talk about. I,
I am for 3.
it's empty for a 4.
Respondent number 3.
3. During the course of the hearing, it was believed that the contempt petition was earlier filed with the contempt case number 21 of the which to dispose of. The council would, however, not produce a copy of submitted that although the copy has been applied for, the same is not available. At the prayer of the petitioner, the this application of the was given liberty to produce a copy. Whereas the matter is called up, this way here and apprised the court that fresh copy was applied on 21/5/2025. Fresh copy of the order. In contempt case number 31 of 2008. However, the same is not stop registry to inquiry to and make necessary endorsements. Copy of this order be brought the notice of registrar. Please take it. The copy of the counsel to the place of the court, copy of the money receipt for 620474 dated 21/5/2025 in support of its contention that the certified copy has been applied for but it's not been received. This again after it did come after 3 weeks. This receipt you take it back. It's after 3. It's a date after copy of this order be brought to the registrar. Yes. Did it come? If it is not listed, make a mention. Get it. Please take back the receipt. No.
Item 27.
Yes,
when I was where we were seeking improvement in the writ petition, since the gradation list has been put under challenge in the writ petition. Now the writ petitioners have filed an objection where they state that they do not have any grievance against the applicants. They admit that we are senior to them and therefore we need not be included in the writ petition. Only difficulty is, my lord, when they challenge the provision, the gradation list, and they want a recasting of the entire gradation list. Our promotional aspects are now being kept on. Although there is an interim order from this honorable court that only any promotions given to the private respondents already included would be affected. But as a whole, when the provisional gradation list stands to challenge,
what is the
my lord, that lordship would find at page 20 of the writ petition, my lord. Page 20. May I read it? In the premises.
Where is that impugned order?
Impugned order.
10. Sorry?
And it's the test 64, madam, annex of 10.
64. And
Subsequently, madam,
the gradation list.
provisional gradation list.
what is 64?
64, my lord, the director of my lord, women and child development passed the
Modified
interim
the
order.
gradation list. 64 modified the gradation list.
My lord.
Yes, placing the writ petitioners, taking the seniority of the writ petitioners from the date of their regularization and not from the date of their initial appointment. Admitted position is we were appointed regularly far prior to them. We stand senior to them. They admit we are senior to them. They don't have any grievance against them. But when the whole provisional gradation, when the whole final gradation list comes under challenge and a recasting is paid for, the department has to stop all processes giving us even the promotion because the recasting would again lead to complications. Is what the department has expressed. So therefore, we need to be implicated either to pace up the writ petition or.
But they are not making any claim against you.
But the recasting of the gradation list is keeping everything hanging. That is our difficulty.
How many posts are there?
For the promotion, 10 posts, my lord. 10 posts are vacant, for which no process is being taken up.
So in these 10 posts, how many of your clients are
7
there?
We are 7.
7.
Yes.
And how many of your clients?
3, my lord.
3.
So 7, we would stand to be promoted whether they get a chance or not. That is their position in the affidavit that they have filed.
What does the rule say in terms of promotion? What is the criteria?
That would be seniority come merit, madam.
Huh?
Seniority come merit, madam.
Under what rules?
That would be under the Social welfare department as of now doesn't have such rules, but
There must be some rules followed.
the
Yes,
precedent which has come in.
some rules must be followed. Or office memorandum from the.
Lordship, as per the,
Is there any TPC here?
Lordship,
How it's.
In my application, I have given that letter, my lord, by which they had called for the gradation list. Writ petition filed, everything has been kept on a hold. Our aspects are now marked because of that. Therefore, we want to.
You are 7. And you are senior to them.
Yes,
They are
definitely.
disputing it. So, assuming it is recasted with regard to the other respondents who were there. Then, my lord,
Legally, we don't suffer.
the claim, these other respondents are not before the court as petitioners by way of the separate.
No.
The really the dispute is between the petitioners and their private respondents.
Yes.
Who are below the 7.
Yes. Yes, everybody is below.
So really the contest between them is with regard to the 3 posts.
Yes.
Out of the 10.
Out of the 10%. True.
So as far as you are concerned with only 7 posts.
Yes.
Which what if you subject to what we would say? If are entitled considered.
Considered, yes.
but here only the direction was passed, Lordship, that to the if any benefit given to the private respondent on the gradation list without leave of the court. That's why, Lordship, it is kept on the hold, Lordship.
Yes.
And one more thing, Lordship, their service was regularized in 2006. Since 2006, Lordship, they have accepted everything, Lordship. Now, when the gradation list has been published, Lordship, now they have come up with these things and they are challenging the seniority of the private respondents, Lordship. This is there. So till 24, they have not done anything, Lordship. So they have accepted their appointment from the date of regularization, Lordship, in that 2006.
What's the rule? Unless the rules are, supposing the rules are on merit come seniority, then of course.
It is always merit come seniority, Lordship.
What's the rule? Mr. Patiri?
As per Mr. Lan, there is no rules, my lord.
But how are you promote them only on seniority? Why are you opposing their? Why are you opposing them?
Regarding implementment. But my lord, he may not be a necessary party, my lord. I have no grievance against them, my lord.
No, you may not have a grievance, but he feels he is apprehensive that your prayer will ultimately affect his chance for promotion. Unless you satisfy the court, the rules are very clear.
And here in the petition, they have not challenged the regularization order also, Lordship, that they have not been given effect since 2001 date of their ad hoc
We are not
appointment.
on the petition, we are on the IA for implementation. Heard counsel for the parties. This application is filed for seeking implement with WPC number so. So the WPC so and so the petitioners have challenged the order dated
27
December 2024, whereby the gradation is in respect of which post? Which post is it? Statistical assistant.
Assistant,
Under the Director of Women and Child Development. Student defined. By which the modified gradation page post of statistical assistant at the office stood cancelled. So, and what else are you challenging?
Challenge The draft, the provisional gradation list also being changed. Page 20, they challenge order
Provisional,
dated 27.
after the earlier one was cancelled.
Yes.
Yes, Lordship. Now the new very.
That page 60. My humble submission.
25.
This would be a totally premature writ.
Huh?
Challenge to a provisional gradation list. It's totally premature.
But it's challenging the earlier cancellation.
The cancellation. Yes, the cancellation he can challenge, but the challenge to the gradation list has to go.
The petitioner also challenge the subsequent provisional list. According to the written petition, the petitioners are petitioners of a better claim than the private respondent there in the written petition. This is the fact. The issue. State by the IA, the present applicant apprehend that the prayer made the petition to challenge the order dated so and so, as well as the provisional prepared by may affect the claim of the it's the submission of it, so here, yeah. They also admitted in the written. However, the event, the provisional petition, even the challenge made the cancellation defied because the fact is not in fact even if the model the absence of matter in fact that a limited prayer, a limited but is particular direction for the that their apprehension is with that there is that's affected you prayer that extent the prayer made the eye are dictated by both of the matter are but because of the statistical that you is depicted by adopting the criteria of merit that there is a problem. The applicant's chances applicant's claim like that and also effective. If the state that every the applicant must be treated as party perfect from
13 to 19.
13
to 19.
by the process of the applicant is already 13 to 9. By the process, there is 1 week. Applicants in, right? Very good, 30 to 13 to 9. Right. Right. It- that- better than the applicant. Is that it? Extra, but if it newly for the 39 may file in the that and the fee is still up.
Deeply obliged. Obliged. But one aspect, my lord, in the IL also, they promoted to the post of CDPO. They are working as secretary assistant, they come to CDPO. I'm obliged.
Deeply obliged.
I have a realistic accommodation for today, my lord. Like, while morning also, yesterday also, while tabling was put, I got wait. Today morning also, I was half wait, man. I'm just waiting for let this matter come on Tuesday.
You are what?
Wait, my lord.
Wait.
Already wait.
Forest department doesn't provide
No, no.
umbrella.
They have. No, I'm not a thing. I'm ravaged by rain, my lord. The rain is not stopping, my lord. I'm just worried. I just want
You
to
are
go to myself.
intelligent of this part of the country. Getting wet is the part of life.
This matter will listen on Tuesday.
As you claim to be born somewhere else, Middle East.
I still feel feverish. There was an unlisted matter. That's it. Tuesday.
Six.
Okay.
Provided it doesn't rain.
Can you please, please, I'm little bit busy, sir.
You're busy. That or 9?
9.
Nine.
All right.
The order has been complied with. In fact, in 2023 itself, my lord, he was reinstated. Within 1 month, again, he was suspended, my lord, for being behind the bar.
My friend has provided me a copy.
So we close it.
Yes, on the basis of that.
Heard there are to be. Wait. Hearing. Alleging willful disobedience. The director. Order is 8-4.
Yes, my lord. 8/4/2019.
They may not carry it out. Right? If the matter is put up, it's report
The second case.
director. 10th of August.
Yes, sir.
Why was it pending for so long?
My lord, they were not aware what to provide, my lord. The last occasion I explained to them and they provided.
It's communication between the respondent and the order. That be of the matter. The order stands by this court does not reach the order. And this is issued.
Large occasion.
Yes.
Can this matter be taken up after some time?
is the matter?
It is regarding non-payment of the retirement benefits.
What benefit?
Retirement benefits.
At 2 p.m.
At 2.
Here we have received instruction due to public complaints received from local residents, the interview was postponed. And now press selection of Anganwadi workers and helpers is given.
Yes.
Lordship may kindly fix the matter next week, Lordship.
Right. Your prayer is only for a direction to conduct the interview.
Yes, my lord.
So they have stated they will conduct.
Now they have cancelled the earlier.
No, they said they will do it within.
And when it was cancelled, my lord, from where the center where I have applied, that center has been able.
We are going through your prayer. Your prayer is to for a direction to conduct the interview.
Interview on the basis of advertisement earlier held.
That will not mean that a center which is closed will be deemed to be in operation.
Earlier advertisement from the center.
They have stated that the earlier advertisement is. You are issuing a fresh or advertisement of the earlier one.
No, here it is written that no new selection of Anganwadi worker will be held.
Now, if on the basis of earlier advertisement, if selection is held, I have no case, my lord.
New process, most probably.
Your instructions is not clear on that.
Yes, Lordship, on that instruction is not. Here it is only said that new selection process will be held.
But assuming a new advertisement is issued, new process, you are entitled to apply.
But my instruction is that the center from where I have applied, now there is jurisdictional part is there, my lord.
Yes. So if the center is closed.
No, not closed. It has merged with the another center.
Whatever it
So I am deprived from applying from this center.
not your prayer here.
Not it was not clear. They have come with that they are going to this advertisement is going to be advertised. But only my instruction. It is now. Yesterday I have received the instruction only. Earlier position was that on the basis of advertisement I applied. Let the selection be conducted. That was my prayer. Now, if new advertisement, new cause of action may arise, my lord.
If it arises,
Yes.
you are entitled to come.
But whether they are going to new advertisement or earlier advertisement, that is also not clear there.
We are closing your petition on the basis of their factors that they are going to proceed with the electoral process.
And my participation in the selection may be considered, my lord. I will participate in the selection.
How can it be if new advertisement issued, then Lordship.
Why do you get such instructions?
Here only as to whether.
You get your instructions at 2 p.m. 2 p.m. Hold them up.
Yes.
Why do you receive such instructions which are not clear? You ask them whether new advertisement hold it. Get an email or instruction, whatever. We'll take it up at 2 p.m.
My only prayer is that I may not be deprived from
Monday
appearing in the selection process.
Monday.
Yes.
For Monday, yeah. I think the government. Fresh schedule. Area?
Area, my lord, Hojai. Lo- Lonka ICDCS project Hojai. ICDCS project Hojai.
Yeah.
Much.
I appear in item number 41, madam. So here in this case, madam, the state level committee, madam, had already recommended my name in 2024, 2024. Now, madam, they have a lot, within the departments, madam, they're communicating with each other, madam. And one is seeking the view of the other. That's what an affidavit is in file, madam.
No, recommendation for what?
Well, upon completion grounds, sir.
Compassion.
Madam.
This application is not, the notification is not applicable.
No, madam, because it was of 2024, the SLC already recommended. Given
Yes,
that.
what do you say, Mr. Chakraborty?
Lordship, in this matter, one order was passed, Lordship. We have been asked to file one affidavit clarifying some stand that's directed by the Honorable Court, Lordship. But in this matter, we have been communicated, Lordship, to obtain some time, Lordship, because it has to be of all the department. That's why, Lordship, I'm seeking some more time in this matter.
In my case, an affidavit is filed by one Arup Bezgur Ramala, is under Secretary Food and Civil Supply Department, claiming that they had written letters the Finance Department.
Making your prayers in both the respect of.
Lordship, in this matter, Lordship.
There are two matters. In Mr. Dotto's writ petition, there is no affidavit.
In my one, there is an affidavit.
No, there is no affidavit here.
Well, that's not common record. It was filed on 26/5, a copy was served on me, madam.
26/5.
5.
This is in item 41.
41.
Sir, M. Dotto, affidavit.
Well, it's an affidavit incorporating the factual position. That's what they call, madam.
Affidavit on 26/5.
26/5, madam.
It's safe, not available. Yes, the court and speak to trace out. I like to see that. Safety. It's still after 2 weeks. That will be listed in July. In July, let them get all their instructions.
It's done, madam. I have no issue. Obliged, Lordship.
Deeply obliged, Lordship.
I mean 40, madam. Here is the position is also similar, madam. The
Both will be listed in July.
pilot have fixed a date.
Third week of July.
I am appearing on behalf of the respondent by. Well, in the last occasion, my lord, the Lord please to give us some time. File an affidavit, to which my lord could not file yet.
You have filed it.
No, we could not, my lord. Can we pay for another 3 weeks?
Petitioner is not here. None appears for the petitioner, Mr. S. Dotto, let us take up.
C Paul for respondent number 1 to 4.
Yes, you are appearing for?
I am for 5.
5. Let's see, Paul for respondent 1 to 4. Matter be listed again after 1 week.
Public.
They have to fill up the post of head assistant within a particular period, as per provision of Rule 8 of the Assam Directorate of Establishment Rules. Now the post is vacant since January 12 December 2024. Lord, may kindly see the rules. 8AA. Every year, my lord, they have taken time, sufficient time, my lord.
Lordship, here, we have already written to the government, Lordship, we are awaiting their reply, Lordship. Lordship will grant us 10 days time, Lordship. In the meantime, we will.
Let it be 1 week, my lord. Last occasion also, they said we will take it.
Oh, yes.
That provision of rule 8AA has to be followed. 8AA, my lord, every year, my lord. 8AA, general procedure of promotion before the end of each year. The appointing authority shall make an assessment of the.
Let them get the instruction when,
10 days, Lordship.
after 10 days. We'll have it on 13.
Lordship.
But that's the pity that.
They have to complete the process.
Yes.
Jail of the. Jail of the. Final.
Yes, health department.
Health.
For 120.
It is. It again. Thirteen. We'll come back at 2.
And it is the contract. Clause area. No.
May it please your lordship. But I'm sorry that I was not present. During the time it was called upon, I am sorry, my lord, I was not. My lord, I was working as a grade one in the office of the respondents. When a penalty was imposed for dismissal of service, I approached this court at page 35. The operative portion is at page 38.
Yeah.
My lord, the dismissal was set aside and a lesser punishment, if possible, they will be giving me. Thereafter, my lord, since the judgment was passed in 2015, I think, my lord, it was passed in 15, nothing was done. and neither any other penalty was imposed on me. I approached this court on 2020 by another writ petition, and ultimately that in the writ petition, it was directed at page 49, para 16 of the judgment.
Yeah.
That in the present case in hand, the respondent has not been able to show that the reinstatement of the petitioner was a consequence of imposition of a lesser punishment. It has been stated in the bar that the punishment provided to the petitioner was never revisited, and in the meanwhile, the petitioner has already superannuated. Under the circumstances, at the relevant portion is at next page, para 19. Accordingly, the request petition stands allowed by directing the respondents to make payment of back wages to the petitioner from such to such period, and thereafter reinstated by order dated such and such. However, as the petitioner has approached the court after a long gap of 5 years, we grant 50% of the back wages with other acute service and financial benefit. Thereafter, 7 lakh was paid, but balance some amount which is still lying after they have passed an order at page 51 saying that I have received credited some amount of rupees 7,64,000 to me, but I have given them a representation stating thereupon that there are a few other amounts which are pending from them to be received by me. So nothing has been done. I have approached this court.
Will issue notice that is
My
there anyone appearing for the?
My lord, I think on notice they will appear.
Mr. P.K. Roy. Yes. All the. And it will put it. List after the return.
Obliged.
Attention of the writ petition shall not be a bar. To ameliorate the grievances.
Obliged, madam.
Hello.
Please, your lordship. Lordship, I'm seeking 1 week's time.
Why was this kept?
Lordship, the council is stuck on traffic.
Huh?
He's stuck in the traffic.
That you could have said then and there. Why did you
No,
keep it?
Lordship, he was here. He went to drop his kid. And now he's stuck in the traffic.
The request made by the council for the respondent matters can be but instead after Mr. A Boro for the petitioner.
I'm correspondent number 5, Lord.
Mr.
A. Borua on behalf of Mr. A. Borua.
Hearing for respondent.
5.
5. MS.
Ida's on behalf of the Upamanna.
Either.
Health Department.
For the health department.
Yes, your lordship.
After 1 week.
Can we fix any date?
13.
13 minutes. I think they have received instruction.
No. We are taking.
13.
Obliged.
Order your lordship, make a list.
Lordship, here I am seeking some accommodation. Mr. Rahul Dar is handling the matter. He is today due to waterlogging, Lordship, he couldn't attend the court. And he has informed me telephonically that affidavit has been sent for waiting. Lordship may take it after a week, Lordship.
What about the provisional one? He is not getting anything. How he
Submission to make.
Lordship, due to what?
Council, PWD unable.
No,
to attend
Lordship,
because
it
of-
is being handled by him. That's why, Lordship, I couldn't submit anything more than that because the files and everything are with
It
him.
is heartening to know that even standing councils, PWD also get water.
He stays in
Forget about common people.
Lordship, he stays in Rukmini Gaon, Lordship, I think.
Well, let it be on Tuesday. He's really suffering from it. Today morning he sent a skit to us. His liabilities and all. There is no reason, my lord. They will have to pay interest. The officer
We'll have it
concerned.
on, have it on minute there.
Yes. Concerned officer will have to pay interest, my lord, because of the delay.
4th.
24.
4th.
4th. They will apprise position of the provisional. The lordship has directed that. Some respect has to be there somewhere.
Earlier, by earlier order dated to 5/25. Respondents were directed to ensure provisional pension. Directed to continue to pay the provisional pension. An affidavit was directed to be filed that effect within 2 weeks. Whereas when the matter is called up, prayer is made on behalf of the understanding of the court, and he is unable to attend court because of season rain, because of waterlogging due to incident rain. Let the matter be listed again on
Witnessing.
court.
I'm appearing on behalf of respondent of court.
Mr. A. Borua for respondent.
Court.
Court.
Okay.
The matter is pertinent to compensation of the coordinator. My case is considered by the district level committee.
What about the notification? 18-9.
18-9 notification is despite to that notification, Lordship, some cases are disposed by this honorable court, Lordship.
We are not going like that.
My case is pending before the state level committee. I have already considered by the district level committee, recommended, showing the post. Thereafter, it is kept pending before
What do
the.
you say, respondent, what do you say?
No, my Lordship, kindly see page 33. Page 33, column 2, serial number 2. Department has a remarks column, my lord. As per Honorable High Court order, so and so recommended the petitioner to SLC for appointment against available grade 3 posts in the Office of the Executive Engineer PWD Department, Hemaji, Territorial Division, as per the report received from the concerned department. But as per the letter received from the Undersecretary PWD Department, Dispur dated 29/12/2003, the 5% quota had already been filled up. Recommendation is there, proposal and answer is there.
Thereafter, Lordship,
If there is no 5% quota, how he will be considered?
That's why, Lordship,
Answer is there.
another special state level or district
And
level
in
committee
compassionate
was
appointment, more,
constituted.
not beyond that 5% can be appointed.
Thereafter, Lordship, on the special DLC meeting was again constituted at Hemaji, Lordship. And
so
in,
far,
in that DLC meeting, Lordship, considering the importance of the Honorable High Court order, DLC meeting again recommended the proposal of Srimati Deepmati Bora Hazarika for appointment against the available vacant grade 3 post in the Office of the Executive Engineer, PWRD, now PWRD, Lordship.
So where is that order?
Earlier order, Lordship.
You are reading from page 33.
33, Lordship.
Second paragraph.
Second part. In that column, second part, Lordship.
Recommended in which post?
The post is not shown here, but against the as per vacancy position submitted by the department. Thereafter, my Lordship, my case is.
When was this held?
It was held on Lordship, page 32, Lordship.
Page
12/3/2024. Page 32, first line, Lordship.
But this is without considering whether the vacancy is available. The first meeting recommended the appointment, but it was informed that 5% quota has been filled up. Subsequently, they further recommend.
Yes, Lordship.
Without, is there any finding that the quota was the post?
That is not me, Lordship, not the petitioner, Lordship. I have already submitted one RTI application, Lordship. In that application, Lordship, I have not received any reply, Lordship. This is page 36, Lordship.
Can you file an appeal under the RTI Act?
I have already filed, Lordship.
Appeal.
Not appeal.
File an appeal.
And my humble prayer, Lordship, kindly direct the state level committee to place my case, Lordship.
No, there is no state level
Because
committee
it is
now.
still not placed.
In view of the notification,
yes,
there cannot be any direction unless you challenge the notification. Unless you make
In
out.
terms of lordship, Jiten Mipun and Abdul Kadir Bakshi, let's say some similar petition has been disposed of by Honorable Court Lordship.
This is court number 5. Court number 5. This is different case. No?
No. In Lordship 2027 Lordship, already it was rejected by the state level committee. Therefore, this Honorable Court is directed to reconsider by placing it before SLC Lordship. SLC was directed to reconsider in WPC 2027 Lordship. My case is still not placed, but this case was placed once earlier Lordship and rejected by the SLC.
কি order আছে এটা থেকে? তোমার ফোন থেকে পাস করছো? এই order তো পাসওয়ার্ড নিয়ে গিয়েছে। কোন date?
Paragraph 5 to the paragraph. Yes.
But these are consent orders. If there is no consent, has he agreed?
No.
It's not agreed. In these matters, the respondent agreed that all right, it can be reconsidered.
2027 kindly 2027.
No. 2027. 2027. 2070.
2070, yes, sir.
Is the Pullo case also?
Paragraph 6 and 7, Lordship.
All right, paragraph 6 and 7. Paragraph 5.
Five
there
and
is a submission recorded that the matter can be reconsidered by the SLC.
And 6.
That's what I'm saying. Here the government council has not given a concession.
Court direction, Lordship.
Court direction is on the basis of consent. Unless he agrees to it, we can't pass an order.
Because my case is already recommended by the DLC, Lordship.
You bring it on record only if you want. See, once there is a notification by the state, either you have to set aside, interfere, read down. How can a direction go to consider or reconsider in the face of the notification without any finding by the court? What will be the effect of the notification? In the state on its own,
In Bakshi case, Lordship, Mohammed Bakshi case, Lordship, it was pending.
You see,
my case is not pending, but it was earlier disposed of by the Honorable Court.
this case is also on the consent given by the respondent. Respondents there had given a consent.
In a particular case, departmental council give consent.
There are 9 in view of the consent of the learned council for the
Yes, Lordship, if the contents are same, in Some
May
other,
be same, but if there is no consent given, then how do we consider it? How do we dispose of these matters?
then let them file lordship.
Either
affidavit.
issue notice here,
Yes, lordship.
if notice is not already issued.
Notice issue.
Notice is issued. You file your affidavits.
Yes, yes,
very
yes.
important file. Bringing it on record, heard, counsel for the parties. Contest will complete their instructions by necessary affidavit. The petitions and deferred to be listed after 3 weeks. Will be responded with their meeting and like Mr. T.C. Tutiel and additional government advocate for respondent. For respondents,
Respondent, my lord. 1 and 2, my lord.
1 and 2, Mr. Upadhyay for 3 and 4, Mr. Chaudhary. 5 and 6.
May I have that order, lordship.
Order given, great. Yes, Mr. Kohli, what brings you to Guwahati?
Lordship, the APSC matter. But in this one, Lordship, actually it's covered squarely by the judgment of this court. This is the first batch of officers who were discharged and they belatedly filed their petitions. These 3 petitions, Lordship, are squarely covered by the judgment of 20th of March 2020.
It's pending in the appeal.
Now it's an appeal. That's right, Lordship. So actually this, and we have mentioned that in our response also to the petitions. They have to be disposed of in light of that order.
Who is for the petitioner?
My lord, I am item number 46,
Ah.
47. In that case, my lord, question, my lord, earlier, my lord, court segregated present 3, my lord, petitions on the consideration of the fact that matter was not heard on merits. In the meantime, judgment was delivered and question involved in the present petition is equally involved in those petitions. It is admitted fact. We are saying that we are the probationer and when you are acted upon on the basis of, my lord, some misconduct, therefore, Article 311(2) is applicable. And same question was that, my lord, argument was advanced in those cases. Therefore, my lord, whatever submission is made by my lord, senior friend, possibly, my lord, this is a correct position. And let us wait, my lord, because when the questions are identical,
Should we
an
close
argument
and
was
wait?
already.
Should we close and wait?
No, not closed.
Lordship may just come to the 22nd of January order. In this, I can read it also, Lordship, 2020. Just one paragraph that writ petitions, so these 3 numbers, Lordship, are fresh matters and yet to be heard on merit.
Yes.
The same may be listed separately on a later date after decision is rendered in the present bunch of writ petitions, numbering 49. Now that has already come, that's why it's got listed again, Lord. This is on 22nd of January 2020.
And whatever decision was taken by a single bench, my lord, now it is under, my lord, consideration by division bench.
We'll defer it to be listed after
Yes.
in July.
Yes.
Or Lordship, whatever, either can work, it can be listed, then I would otherwise press that Lordship, these can be disposed of.
No.
For them pending, because I understand that they are squarely covered by this. Once they are covered, there cannot be a fresh ground of appeal on a judgment rendered on this. And should they wish to file their appeal in the meantime, because the matter is hearing, then whatever comes in the appeal, they will be the beneficiary.
Whatever decision will be taken by division bench, that will apply in our case, my lord. So, my lord,
it can't apply.
if the matter is closed, then we'll have to again go to division bench, my lord. So appropriate equitable, my lord, equity will be, my lord.
Is trying to submit that in the event the appeal reverses
Yes.
The decision.
the decision.
Yes.
Then
there is a possibility.
Good for a fresh hearing or whatever else.
Then perhaps, Lordship, a longer date may be more desirable.
Sorry?
A longer date may perhaps be more desirable. Why keep it in July a little later?
And we are hopeful that the decision will come in your favor.
In whose favor?
He's very kind, Lordship. He said my favor. I thought I'll immediately accept the kindness.
Heard learned counsel for the party, it is submitted that the issues in the writ petition, named discharge of the petitioners during the period of probation, was answered by a coordinate bench in a bunch of writ petition which came to be decided by the judgment and order dated so and so. Probably those writ petitions were dismissed. So, however, by order dated 22/1/2020, since these petitions were not heard on merit, they were directed to be segregated and listed separately again. So those writ petitions in the meantime came to be dismissed. So presently, the judgment and order passed by the coordinate bench rejecting rejecting the writ petitions in those bunch of cases is presently under appeal, and the matter is being heard by the bench. So counsel of the bar are agreed the matter be listed in the first week of August.
I think that.
At which time it is expected that the writ appeals will be finally disposed of.
Deeply obliged, grateful Lord.
It's listed the first week of August on a date to be fixed by the rate.
If I may also press for my learned colleagues, Mr. Ankit Roy and Ms. Nimisha Menon. She's in the other court with the writ.
You can
We'll give it.
Give it to the
I'm so
court master.
grateful.
Let us have it in the second week of August.
Yes, Lord, perhaps better.
Second week of August.
Grateful.
Fixed by the rate. The council of the bar are requested to intimate the court on the next 8 weeks if the writ appeal judgment in the meantime comes to be disposed of.
Grateful.
Last occasion, Lokip has directed the government council to obtain the service record of the petitioner.
Lordship, I have the instruction. Just received yesterday evening only, Lord. They have provided me a report, Lordship. Point is categorically stated, Lordship, the petitioner was the sole senior assistant there and he was handling all the files and service books, Lordship. Page 2.
So there was a disciplinary proceeding, some punishment was imposed.
Yes, not punishment or dismissal.
Dismissal.
Yes.
Against that, you filed an appeal.
No.
Did not file an appeal.
Directly approach. Well, we have initially in a lordship.
Appeal has not been
Lordship,
preferred by Lord.
whatever lordship that as his salary was not released, lordship, we have filed writ petition. And this honorable court has directed the respondent to examine the on the first day, lordship, that the case was disposed of and directing the respondent to examine the matter and totally pass appropriate. As the said order was not complied, lordship, we have filed in contempt proceeding. In the contempt proceeding, they have filed an affidavit, lordship, and wherein the affidavit. That time we come to know that the already dismissal order was.
What about the salary during the time?
That was also not released. That was not released. Whereas the respondent has now admitted that the same person has the jurisdiction who has issued the page 37 lordship, whereby the petitioner was appointed as a BLO. Whereas the lordship thing is that the learned government council is appearing for both the departments. Whereas the contradictory stand in the fishery department, they have taken stand that the said circle officer has no jurisdiction to issue the order of appointment. Whereas the now the respondent 4 has the deputy commissioner office has passed file affidavit. They have admitted that he has the jurisdiction. Now contradictory stand of the department of the fishery department as well as the deputy commissioner.
So What we want to know, why don't you urge it before the appellate authority?
No,
Just
the-
actually to
Lordship, in the meantime, Lordship, the order was passed in the year 2020 itself. Lordship, wherein the contempt proceeding was pending, then only we came to know. Only the 2 years, because in the year 2022 we came to know. Order was passed in the year 2020 itself. So that's why we have approached the, because during the pendency of the requisition, and accordingly the Lordship,
it is under discipline and appeal rule.
yes,
Lordship.
Lordship, if last order, Lordship, page 120.
You filed an appeal. Mr. Kolida, you filed an appeal.
Now, again, if the
We
remanded,
wanted you to file an appeal.
we again remanded the matter back to the appellate authority. Now, from 2000,
Because there are facts involved here.
factual issues, they have admitted that the and lots of people of the Peru.
There is no admission, Lordship. He is not-
You are questioning, what is the ground for challenge of the disciplinary?
Notice was not issued, apparently.
Their ground is that you had kept the service book with you.
Whereas the appointment order itself, the appointment order, therein also his address is reflected. Appointment order he has issued. Appointment.
All right, but that is what we want.
And Lordship may appreciate one thing, that if now they have taken the ground that he has kept the record. Lordship. Where is the FIR has been filed? Is there any FIR has been filed against the petition? Any averments regarding the filing of FIR? He is the government employee.
Readings are complete.
Yes,
Lordship, it is
I heard
complete.
learned counsel for the part. To be listed for hearing. The month of August.
Lordship may grant liberty to mention. Lordship will grant
It will be listed in August.
liberty. In liberty to mention.
You don't need liberty, you can mention if you want.
Highly obliged.
Deeply obliged, Lordship. Lordship, can I take back the instruction?
Yes, Mr. Jogar.
This matter relates to prolonged suspension of the petitioner matter. And the petitioner was placed under suspension under 1/24/10/2012 22 matter. Pending trial of departmental proceedings, possible at page 51. বিভিন্ন বর্মন্ত বিভিন্ন বর্মন্ত
51,
51 madam.
Okay.
So, married madam. Whereas upon receipt of the memo number so and so dated 21/10/2022 regarding arrest of the employees of Guwahati Municipal Corporation in connection with vigilance police station case number so and so, and pending trial of departmental proceeding, the services of the following engineers are hereby placed under suspension with effect from 24th of October 2022. So, mine the serial number 3. Then, you are placed under suspension. Then, this honorable court, on 19/12/2020, was pleased to grant him bail, with some conditions. And subsequently, on 29/12/2022, so-called notice was issued he submitted his reply also, my lord, denying all the charges. Then, my lord, as my lord, my lord, no review was, my lord, done within the stipulated period of 90 days in person to the mandate of my lord Ajay Chaudhary, my lord. The petitioner approached this honorable court and filing a petition, my lord. And my lord, this honorable court had an order dated 24/5/2023, my lord, page 73. And my lord, a relevant portion at my lord, page 74, last paragraph, paragraph number 7, my lord. Upon hearing the learned counsel for the parties and taking into account that the memorandum of President was issued on 29th of 2022, and the petitioner has also submitted a reply on 6/1/2023, and the disciplinary proceeding is presently going ahead with the criminal proceeding. This court does not find any justiciable ground for interference with the suspension order. However, it is made clear that it is the mandate of the law that there has to be extension of suspension order by a reasoned order, which, as per office memorandum dated 4/2/2020, is to be done within a period of 6 months. Taking into account that the learned counsel appearing on behalf of the respondent number 1 submits that the same would be done within a period of 15 days from today, this court is not inclined to interfere with the order of suspension or the further continuation of suspension, subject to the respondent authorities passing a reasoned order within 15 days from the date of a date a certified copy of this order is served upon the Commissioner GNC. So, my lordship, may kindly go to one desk memorandum, my lord, that 4/2/2020, which will be at page 70, my lord. May I read, my lord? 4th of February 2020, office memorandum.
Page number?
Page number 70, madam. 70.
70. Yeah.
Honorable High Court, Guwahati, in its order dated 30/11/2017, in a series of writ petitions, the lead case being so and so, has directed to issue a notification indicating the law laid down by the Honorable Supreme Court in Ajay Kumar Chaudhary versus Union of India.
Sorry, just 1 minute.
Yes.
In this matter,
Yes.
we are this we are aware that there is a circular and it has to be carried out. Now, you are suspended by the order at page 81.
No, madam, 51, madam.
51.
51.
51. That is on 24/10.
Yes, madam.
Then, when was the extension made first?
15/6/2023.
Page number?
Page number, my lord.
81.
Yes, madam.
In the meantime, there was no
extension, nothing is there.
Nothing was done.
And madam, this extension order is also, madam, until further order. No scope of periodic review, my lord.
Yes, Mr. Nayak.
First, I'd like to place one provision in the discipline and appeal rules, that is 14, Rule 14.
Yeah.
So this is an appeal provision against the order of suspension, Lord. So one provision is already there, that provision has not been exhausted, Lord. That is my first area. Secondly, Lordship, if we come to the Ajay Kumar Chaudhary judgment, Lord.
No. We'll come to judgments later. You explain the fact first.
Yes. Lordship, so far, on receiving the complaint, Lordship, GMC itself conducted an inquiry and a report was furnished on 21/7/2022.
No, we are asking you 24/10/22, he was placed under suspension.
Yes.
As per even leaving aside the judgment, as per the circular, government circular.
Yes.
Where is that government circular again? 70.
Yes.
70.
70.
All right. 24/10,
2020.
he is suspended ordinarily by at least January, end of January should have been extended or disciplinary proceedings initiated. First extension comes in 15/6.
No, Lordship, he was released on 19/12/2022.
19/12. Okay.
Yes.
19/12, then when was he, when were you informed?
And so cause was issued on 29/12/2022. So that is immediately after law. Within 10 days of his release, the so cause was issued.
Where
What's
is
my-
that? Is the page number?
Page number 52 is the bail order law. Page number 52 is the bail order. This is dated 19/12/2022. Then Lordship, page 57 is the so cause Lordship. 29/12/2022.
Sorry, page number?
Page number 57 is the so cause Lordship. It's 29/12/2022. Then Lordship, he filed his reply on 6/1/2023. Page 59.
Reply is at page?
59. 6/1/2023.
Then what is the stage of the inquiry now?
It's going on, Lordship.
Still going on?
Yes, Lordship. Then Lordship, thereafter, Lordship, in the meantime, CBI, CM Vigilance also filed its search sheet on 11/1/2023, Lordship. Additional affidavit.
11/1?
11/1/2023.
Your prayer here is for setting aside hope?
Setting on the suspension order as well as my lord, extension order.
No,
But
his
this
basic
is within the prescribed period.
No, my lord, as per OMD, it is correct. my
No,
lord.
Lordship may kindly see one document at page 72. This is an order passed by our High Court, Lordship. Same petition, page 72.
Yeah.
It was basically filed for not reviewing the suspension order within a period of 90 days, Lordship. And Lordship passed the order at 75, page 75. I'm sorry, Lordship, can you take the last few lines of page 74? Here, Lordship may kindly see last 3 lines. which is as per office memorandum, this 4/2/2020 has already been taken note of. Next time, taking into account that the learned counsel appearing on behalf of the respondent one submits that the same would be done within a period of 15 days from today. This court is not inclined to interfere with the order of suspension or the further continuation of the suspension subject to the respondent authorities passing a reasoned order within 15 days from the date of certified copy.
Same suspension order. Same suspension order.
Same lot.
Yes, my lord.
So time was granted to the authority.
My lord, I have challenged my lord that my lord, region order, my lord, here.
What
The
reason order?
15th, my lord, the 15/6/2023 order has been passed, my lord, in pursuant to this order, but not indicated here, my lord, but my lord. This honorable court, my lord, on 24/5/2023, my lord, by disposing this, that petition, my lord, directed to pass a reason order within 15 days, my lord, in pursuant to the, my lord, office memorandum dated 4/2/2020, my lord. And my lord, lordship kindly come to that reason order on 15th, that page 81, my lord. Page 81, my lord, 15th.
See, you see the findings of this court.
Yes, madam.
Court is not inclined.
Yep.
Please read it. Page
Yes,
number
madam.
75.
Yes, madam. Paragraph 7, madam.
Yes.
Up
End
here-
of paragraph 7.
Yes, page 79, madam.
75.
Madam, we have annexed 2 times lots. Yes, madam, 74. Yes, page 74, paragraph 7, madam. Upon hearing the learned counsel for the parties and taking into account that the memorandum of charge was issued on 29/12/2022, and the petitioner has also submitted a reply on so and so, and the disciplinary proceeding is presently going ahead with the criminal proceeding, this court does not find any justifiable ground for the interference with the suspension order. However, it is made clear that it is the mandate of the law that there has to be extension of the suspension order by a reason order, which as per office memorandum dated 4/2020 is to be done within a period of 6 months. Taking into account that the learned counsel appearing on behalf of the respondent one submits that the same would be done within a period of 15 days from today, this court is not inclined to interfere with the order of suspension or the further continuation of suspension. My lord, Lordship kindly express this, subject to the respondent authorities passing a reason order within 15 days from the date of certified copy of this order is served upon the commissioner GMC. So accordingly, my lord, as per direction, my lord, we have submitted the certified copy, and my lord, then impugn extension order was issued on 15/6/2023.
Is it your ground that this order which was directed to be passed?
Yes.
In terms of page 75.
Yes.
Is not a reasoned order.
No, my lord, that order is, as per my submission, my lord, that order dated
What the court understand, let me think aloud.
My lord.
Para 7, the court has returned a finding that the court does not find a justiciable ground for interference with the suspension order.
At this stage, my lord.
No, not at this stage. We are reading what is there in the order. It does not find.
My lord.
So the suspension order, the court does not find any ground to interfere. Which otherwise will come to an end by flux of time, if not extended. Let us understand that. So far as the extension order is concerned, see, in view of the submission that it shall be passed within 15 days. Court further said that we are not inclined to interfere with the suspension or continuation. Subject to respondents passing a reasoned order within 15 days.
Yes.
Now, number one, whether reasoned order was passed within 15 days or not.
Yes.
Firstly, whether order was passed within 15 days or not.
Yes, my lord.
It was passed. Whether this order is a reasoned order.
As per my lord submission, it is not a reason order.
Where is that order?
That my lord 15/6/2023 order, my lord.
Page number?
Page my lord 81. Page 81, my lord.
How can you say 81 is not a reasoned order?
May I read, my lord?
Reasons may be sufficient, not sufficient is a different issue.
Reason, my lord.
Reasoned order means give reason.
my lord, but my lord, reason must be justifiable ground would be there, my lord.
Then you're questioning the justiciability of the reasons.
My lord, my lord, my lord,
Then you are questioning whether these reasons are sufficient to pass this order.
Lordship, kindly go through the, my lord, my lord.
We are asking you something. Because this order is an order at your invitation. Page number 74, 75
Yes, my lord.
is an order passed by the court in your petition.
Yes, my lord.
You have agreed to this order.
Yes.
There is no appeal against this order.
No, my lord.
No review against this
Yes,
order.
my lord.
So the order says we decline to interfere with the suspension or the extension subject to a reasoned order being passed within 15 days.
Yes, my lord.
So it was passed within 15 days.
Yes.
Prima facie, this order appears to be a reasoned order.
My lord, but my lord, my lord, as per Ajay Chaudhary, my lord, it is always open to challenge that order, my lord.
Now you are entitled to challenge.
Yes, my
We
lord.
hear you.
So, my lord, my
Okay.
case is that, my lord, this is not a reason order, my lord, for continuation of suspension.
We'll hear you on that.
And my lord, I have stated in my paragraph 18 also.
Had it been suspension, had it been a case that the time period has been completely not adhered to.
My lord, as per my lord, this order, my lord, 15623 order, my lord, the respondent authority is unable to, my lord, proceed for departmental proceeding due to, my lord, they have no, that relevant files are not available with them, my lord. And my lord, that's why, my lord, they have extended that, my lord, that the departmental proceeding also, my lord.
What is the stage of the department proceeding?
Not as per my instruction, my lord. The so-called, while my lord, I submitted my application, my lord, for my lord inspection of documents, my lord, they have informed me that all the files are in the possession of the, my lord, Chief Minister Vigilance Cell. So, my lord, they are unable to, my lord, give the opportunity for inspect of the documents, my lord.
You have not even filed the written.
No, first, I have filed one so-called reply, my lord. Then, my lord, secondly, my lord, subsequently, they have again, my lord, one supplementary so-called notice was issued, my lord. So this, and my lord, so far criminal case is concerned, my lord, till date, my lord, my lord, copy has not been served, my lord. So it is a very preliminary stage, my lord. Well, basically, my lord, I am the 2018, my lord, 17 SCC case, my lord.
So even in that matter, it was not interfered. You are referring to Ajay Chaudhary.
No, my lord, that's another matter, my lord. 2018, my lord. 2018, 17 SCC 677. Relevant, my lord, paragraph 24 to 27, my lord. And
2018, 17. What was this fact at this stage?
My lord, here, my lord, one, my lord, IPS officer was placed under suspension, my lord. And he was promoted, yes, promoted. May I read last paragraph? 686, paragraph 24. The first respondent was placed under deemed suspension under Rule 32 of the All India Service Rule for being in custody for a period of more than 48 hours. Periodic reviews were conducted for his continuation under suspension. The recommendations of the review committee did not favor his reinstatement, due to which he is still under suspension. Mr. So-and-so, learned senior counsel appearing for the first respondent fairly submitted that we can proceed on the basis that the criminal trial is pending. There cannot be any dispute regarding the power or jurisdiction of the state government for continuing the first respondent under suspension pending criminal trial. There is no doubt that the allegations made against the first respondent are serious in nature. However, the point is whether the continued suspension of the first respondent for a prolonged period is justified. The first respondent has been under suspension for more than 6 years. While releasing the first respondent on bail, liberty was given to the investigating agency to approach the court in case he indulged in tampering with the evidence. Admittedly, no complaint is made by CBI in this regard. Even now, the appellant has no case that there is any specific instance of any attempt by the first respondent to tamper with evidence. In the minutes of the review committee meeting held on 27/6/2016, it was mentioned that the first respondent is capable of exerting pressure and influencing witnesses, and there is every likelihood of the first respondent misusing office if he is reinstated as Inspector General of Police. Only on the basis of the minutes of the review committee meeting, the Principal Secretary, Home So-and-so Department ordered extension of the period of suspension for a further period of 180 days beyond so-and-so filed order that so-and-so. This court in Ajoy Chaudhary versus Union of India has frowned upon the practice of protracted suspension and held that suspension must necessarily be for a short duration. On the basis of the material on record, we are convinced that no useful purpose would be served by continuing the first respondent under suspension any longer, and that his reinstatement would not be trade to a fair trial. We reiterate the observation of the High Court that the appellant state has the liberty to appoint the first respondent in a non-sensitive post. And here, in my case also, my lord, two my lord accused has already been reinstated, my lord.
So,
in my additional affidavit, we have said
your suspension and the disciplinary proceedings are different domain. You are suspended because the proceedings are. Is there any challenge that these proceedings must be concluded at this stage, or that criminal proceeding and disciplinary proceedings on the same time cannot proceed? Is there any challenge to the debate?
In my just first petition, that part was there, my lord.
But that was not answered.
Yes, the court observed that, my lord, the criminal trial, both may be continued, my lord.
In this writ petition, you are only questioning the suspension.
Suspension, my lord. That's not extension.
Extension.
Yes. And my lord, in my additional affidavit, my lord, so lordship kindly go through that charge sheet, my lord. I have annexed the charge sheet, my lord, in my additional affidavit, filed on 24/1/2025.
How many months or years?
Lordship, last order in this regard was passed on 21/3/2025,
In the
Lordship.
disciplinary proceeding.
Yes, yes, Lordship. In the meantime, we have already received back some of the files, Lordship, that were in custody of the Vigilance
You
Department.
had initiated it in December.
Yes.
December 23,
Yes.
22,
Yes, Lord.
22.
Thereafter, Lordship, for some period, Lordship, it was deferred because of the once of records, Lord. It was seized by the.
When was the last date? When was the last date of which the proceeding that?
Lordship, last proceedings, Lordship, this is ordered or dated 21/3/2025. By which Lordship, therefore, Mr. H. Nabis, ACS Joint Commissioner cum Inquiry Officer, and Mr. T. Bipul Bora, ACS Assistant Commissioner cum Presenting Officer, are hereby directed to complete the departmental proceeding and conduct inquiry into the searches frame against Sri Hiranya Varman EE, code number so and so. So a direction was issued. They were pressly appointed, Lordship. And
Direction was issued by whom?
it was by the Commissioner, Lord.
So they
In
are
the-
appointed now.
Yes, in the month of March, Lord.
25.
Yes.
So what is the
So
status now?
thereafter, Lordship, I have not taken any status, Lord.
Please get
Manoj,
the
status.
updated status.
Manoj, they are unable to produce the record, my lord, for my inspection, my lord. So, Manoj,
So let us find out what is the last date, what orders have been passed.
but Manoj, how I can file my reply, my lord?
That's right. So I want to find out what is the order passed.
Just to rebut this submission, Lordship, if Lordship comes to page 87, Lord, once, page 87.
'87.
Yes, Annexure P.
Huh?
Annexure P.
NHRP.
As desired by you to inspect the documents as per search sheet issued against you is hereby allowed to inspect the same in the presence of the undersigned at the Ujan
That's
Bazar.
all right. You get all the information necessary, including whether WS has been filed, not, what is the status. You give us these inputs by next week.
Lordship.
What is the status? We'll consider whether any further orders are required. We pass on in that regard. So far as your suspension is concerned, I think it has to be laid to rest. Because the earlier court had already given a finding saying that unless the reasoned order is passed.
Yes. Subject to the, my lord, passing a reason order.
Passing a reasoned order.
Yes.
Now, prima facie, we are of the view that this is a reasoned order. Whether these reasons are germane or not, we will examine it.
And my lord, my lord, that's why my lord, I am before your lordship.
We'll examine it,
Yes.
whether these reasons
Whether
are
the reason
sufficient
order or not.
based on the records or not.
Yes.
But you can't say that this is not a reasoned order. So if it is a reasoned order, then no interference of a suspension.
And my lord, second,
unless we set aside.
and my lord, second will become, my lord, that prolonged suspension, my lord.
That is what we
Because
want
it
to
is
find out. The prolonged suspension is because of the prolonged disciplinary
Yes,
proceeding.
but they are unable to proceed the disciplinary proceeding, my lord, due to, my lord, lack of records.
Can you get it by 13?
Yes, Lordship.
Yeah, get it by 13.
Fine.
Hard counsel for the parliament. Although the writ petition is filed, putting to challenge the suspension of the petitioner and subsequent extension on a liberty granted by this court by earlier order, by an order, the liberty granted by order dated 24/5/2023, passed in WPC so and so by coordinate bench in a writ petition filed by the petitioner in an earlier point in time. It is also said that although the disciplinary proceedings were initiated against the writ petitioner as far back as December 2022, the same has not yet been completed. So Mr. Nayak, on instruction, submits that in March 25, the fresh inquiry officer and a presenting officer have been appointed. He, however, has no information as to the status of the progress of the disciplinary proceedings as of date. He prays for some time to complete his instruction. So, parallel is going to be listed again on 13th of February, 13th of June, on which date the parallel counsel for the respondent will apprise the court the status of the disciplinary proceedings initiated against the petitioner and whether the petitioner has been permitted to file his written statement end of legal or whether he was given an opportunity to inspect the documents which the petitioner claims he had prayed for. With this information be placed before the court on the next day. District Court.
This case, my lord, I have received some instruction from video, my lord. I'd like to file a short affidavit so that lordship can dispose of the matter.
Yes.
Oh.
Mr.
Yes.
It's not. As of the respondent submits the instructions that we received, we would like to file an affidavit each time. That will be listed in the month of July.
My lord, can it be on June?
June.
Non-payment of salary is very hard.
2 weeks. That will be listed on 18th. Like 18 June.
Of like.
Hello.
In this matter, we are supposed to get the records. We are supposed to get the records in connection with the departmental proceeding, is it? But the decree is still awaited from their side, lordship.
What is awaited?
The records of the decree. So therefore, lordship, I need to pray for lordship, another 2 or 3 weeks time, lordship. Because the order of this for this has been well communicated on 28/5. So, only 2 days have passed, lordship. Today is 38. So I pray for lordship 2 weeks.
It's a matter, my lord, where the departmental proceeding was initiated 4 years after the petitioner had retired without the sanction of the governor. And I was praying for provisional pension when lordship had pointed out that if 21 does not apply, 22 will not. That part. Now, 18 on, I'm waiting for my pension.
Council for the that. Yes. Further time. Pray for further time. You go to the of the responded when required to pay by that is passed by earlier 21. This weeks.
Date is what I could pray for, but otherwise.
Date. Have it on 18th.
18th.
Obliged.
Please, your repeat.
Yeah.
The family pension matter, lordship. See the last order, lordship, 25.
Last occasion, Honorable Court directed to bring the instruction as result of state status of the state and by the. And that instruction is awaited, lordship. Kindly grant 1 week time.
That 1 week.
Yeah.
Right. Sir.
RL Sutia.
R.
L Sutia.
M.
L.
RL. Right.
Also, dead may be fixed.
After 1 week. After 1 week, we'll come on a date.
May I please, your lordship? My lord, the petitioner was selected for the post of CRPF. Nearly 4 months he served as CRPF. Thereafter, it is the allegation that he has some
mental problem or health problem and he cannot participate in the combatant duty. So I filed a writ petition and that was disposed of to consider the matter by medical board. Medical board also gave opinion that I am not fit for combatant force. Now I have filed this writ petition on the ground that if I am not fit for CRPF combatant force, then I may be given another post. Beyond Chowkidar, there are so many other posts because I have qualification and there is no bar as such, my lord. This they have filed an affidavit. In affidavit, they have cited some judgments of the different courts, my lord. But all those judgments are not at all connected with this case because those were regarding the health condition. Now I am on not on that. I want that my post may be considered against any other post. So in this regard, my lord, there are a lot of judgments. Lordship may kindly see this one. Narendra Kumar.
What is the defect? Medical condition?
No, medically, my lord, I have become unfit. I am not challenging that now at present. Now at present, my only prayer is this.
You are discharged. He is discharged.
No, not discharged.
Then?
He has been declared as unfit.
For combatant role?
Yes.
Ah.
Now, Lordship may kindly see this judgment. If in such a position,
come, tell us the fact.
Yes. I am telling.
What is your grievance?
My grievance is that I have been told as unfit for combatant force.
Right.
So I have accepted that.
Ah.
Now, as I have passed higher secondary examination and as I have other qualification, there is scope also that I may be appointed against any other post.
That is why we asked you that are you discharged?
No, not discharged, unfit.
If you are unfit, then are you getting your salary?
No.
Not getting your
Training.
Training period. That's right. You are because of a lower medical category, you are not considered competent and therefore
Yes.
you are out.
Yes. Now my present prayer is for another post. That any other post, like beyond
You
or
are in the
Chowkidar.
training period, but you have to complete your basic training.
The basic training for becoming LDA or clerk or Chowkidar, no training is necessary.
Is necessary. Basic training for all.
And if that is necessary, I will go through that. If necessary, then I will go through that
They
process.
have held that you are medically unfit to go through.
No, medically unfit for combatant force, not for other civil posts.
Where is that order? Where is the order? Acute psychosis.
Yes. It is S26. Bottom.
Where is your appointment?
Yes, my appointment letter, Lordship may kindly see page 22.
Your appointment is for Constable GD. You are selected for appointment as Constable GD.
CRPF.
CRPF.
Yes.
Then?
Lord, I was appointed against that post. Thereafter, nearly 4 months I served. I got my salaries, etc. And thereafter, it was found that I am not medically fit for combatant force. In that view, earlier there were medical certificates in my favor. in my favor, here is 4 certificates which say I am fit. But suddenly, perhaps due to my luck, I fell in illness and some difficulties arose. So now, thereafter, when the matter I was declared as unfit, then I applied that I should be given another post like LD, etc., because I have those typing qualification, PG diploma, I am higher secondary pass, EA operator course, CC course, extra certificates are there.
This is the recruitment process.
Yeah.
You applied, you are selected,
Yes.
you are put up for training. You are found to be medically unfit. You will be rejected.
No, but that is very easy.
But the
Nowadays, fellows,
alternative employment that you want is again a process of recruitment.
that may be done because I have already qualification.
We can close your petition with an observation that this rejection on the medical ground shall not be considered to be a hurdle for fresh selection process in any other job.
Yes, in the second manner, I have given the judgment. Kindly see that para 7 of Narendra Kumar Chanda. Para 7 may be seen. Article 21 protects the right to livelihood as an integral fact of right to life. When an employee.
You read the opening line of paragraph 2. And please read it aloud.
Yes. That is the ratio. However, I am reading paragraph 2. The appellant was working as sub-station attendant in the pay scale of rupees so unfortunately had he.
That's it.
Hello?
He was working as a regular employee. You are not even in the regular cadre. You are in the probation. You are under training to find out whether you are suitable for regular appointment. You have been found to be medically unfit. How can the ratio be applicable here?
Of course, that is true, medically unfit, but medically unfit for this types of arms duty. But some
You show
consideration.
us any authority to say that even if you are found to be medically unfit in the training period, your case can be considered sympathetically for other jobs in
That is a Narendra Kumar. Let me read, my lord. Narendra Kumar para 7 says Article 21 protects the right to livelihood as an integral fact, facet of right to life. When an employee is afflicted with unfortunate disease due to which, when he is unable to perform the duties of the post he was holding, the employer must make every endeavor to adjust him in a post in which the employee would be suitable to discharge the duties. Asking the appellant to discharge the duties as a career attendant is unjust.
Mr. Mahmood, please try to understand you are a very senior, respectable counsel. You are asking for a writ order.
Yeah.
You must establish your right. What is your right?
No, I have no right, but I have legitimate expectation.
No,
On the ground, I was selected.
No, you are selected for a combat duty.
Yes.
It is not your prayer that notwithstanding this medical ailment that you are facing, there are other collateral materials to suggest that you are otherwise fit for the same duty.
The Lordship may kindly observe that, and in future, if so, employment is done, advertisement is made, my case may be considered suitably.
Because in a place recruitment, they have to run for the place medical process.
To do it, we are not preventing you.
Yes, ma'am.
We are saying that this medical certificate don't debar it for fresh appointment. If in the fresh test is found to be inflicted the same ailment, take step. He may not be.
No, my first appointment as that may be taken into note considerably.
Not an appointment. You are in probation, subject to clearing that training, etc.
That is the later stage. But first time I was appointed, I did duty for nearly 4 months. I am on record. I am submitting on record. My appointment letter is annexed here. In that view, my considering that may can be taken into note. That only I think my purpose would be served.
if you can give us some authority to say that in these kind of cases, there is a scope to reconsider cases and by considering their continuation of their employment in
Yeah, yeah, the
job,
case, my lord,
not
it's not
required.
was case, my lord, if your lordship kindly bear with me. Narendra Kumar, he was the station master.
Who?
At this Narendra Kumar's case, he was a sub-station attendant. So
In Narendra
Then-
Kumar's case, he's a regular employee. We are
Regular
talking about provision. You are a provisionate. That too in a central armed police force.
yes, thereafter court said that
The name of the organization itself is a
Yes.
central arm. So you must go for this basic training.
actually, my lord, when I was appointed, before that also there is a medical examination.
Maybe you are not challenging this medical examination. You are not
No,
saying.
I am not challenging
So
now.
then
Not
it is
challenging
not your
because-
case that this
Because
medical board finding is
no,
incorrect.
no, I am not challenging because I do not want to make my life miserable. So some observation that
I heard Mr.
Yes.
M.E. Mahmood, learned counsel for the petitioner. This petition is filed by the respondent. Anything to submit? madam?
I don't, in case number 50, you have stated that all the posts in CRPF, case number 50, paragraph 10, my lord.
50.
50.
Yes.
All the posts in the CRPF are the competitors and each and every member of the CRPF, irrespective of cadre, has to clear the district bench.
Yes.
That is my lord. It cannot be added to others.
Heard learned counsel. What is this petition is directed by the petitioner? Challenging. Which order are you challenging?
I am not challenging the order of medical board. So only my alternative submission was that I should be given another post according to
Is there
my
any
quality.
order? Is there any order saying that you are to be discharged? Where is the discharge order? This cancellation, page 27. Putting to challenge the order dated.
Yes. 26 and 27.
15/9/2017. 2017.
In between, writ petition was filed, and that was disposed of, asking the authority to consider my case afresh to medical board. So thereafter, medical board cancelled my appointment letter, and thereafter I have approved. That is why delay.
The writ petitioner challenging the order dated 15/9/2017. The petitioner had applied for and was recruited the post of constable GD pursuant to the recruitment process initiated by the for the Central Armed Police Force. So petitioner was selected in the recruitment process for appointment as Constable GP in CRPF. ID letter of offer of appointment dated 11/5/2017. During the training period, petitioner was found to be suffering from acute psychosis due to stress. Stop. In view of the medical board finding, the the medical board upon conducting the medical examination at the composite hospital, GC, CRPF, Guwahati, had found the petitioner to be within a court's case of acute psychosis, quotes closed, and had declared him unfit. In view of such circumstances, his candidature post of Constable G was cancelled by order dated 15/9/2017. So, being aggrieved, the petitioner approached this court by filing the PPT 6570/2017. Where is the order of the court passed in the earlier writ petition?
S32.
By order dated 14/12/2020, this court disposed of the writ petition that a further opportunity, with the direction that a further opportunity be given to the petitioner to be subjected to medical examination. It was directed that if the result of the medical examination is in favor of the petitioner, respondent authorities will pass appropriate orders on the cancellation of appointment of the petitioner, and if it is against the petitioner, then the petitioner be duly informed. So, pursuant to this order, the petitioner subjected himself to medical test, and however, in the review medical board, which was held pursuant to the direction of the court's order, the petitioner was found to be pursuant to the direction of the court, petitioner reported before the composite hospital group center CRPF, stop, was referred to the departmental psychiatry, DLCH. So, the clinical psychologist report dated 25/1/2023 revealed that he was seen, that he was examined for psychological assessment. Stop. And the report reflected that he was an old case of acute psychosis, within brackets, stress induced, and keeping in view the nature of the past history, which is known to cause relapses under stress, and the recent psychometric analysis report suggesting presence of anxiety in the patient, and the inherent stress and strain of service as a member of the service in a armed forces with easy accessibility and the need of handling firearms and ammunition. The review medical board decided, came to a conclusion that the petitioner is not fit for service as a combatant in the armed forces. And consequently, his case for appointment to the post of constable D was not considered and rejected on the mental grounds. So, the arm is by challenging an order is this of 1st of March 2020. Where are the learned counsel for the petitioner submit that the petitioner was duly selected in the selection process and was given the appointment letter. He had completed about 4 months.
Yes.
4 months of training when he was considered to be medically unfit and discharged. Otherwise, the qualification, other qualifications, and therefore he is fit to hold any other position required. Competent or trade.
I think there are some other diplomas, including typing.
He also hold other diplomas in diplomas in type, and therefore, according to the or clerk, LDA, which the important are required and going to reporting. That petitioner having been selected for the post, merely because he suffered from medical ailment reflected opinion of the medical board, which clearly suggests that he is not fit for combat. He cannot be discharged without first considered other duties, not have any role competent. MSc Gayo, the other he represents relies on counter-academic file like the process. He submitted that CRPF is the central armed force and is considered to be armed. It's an armed force. Yes. And its basic duty is to maintain law and order, internal security, on counter-insurgency operation. Wherever needed. Therefore, all posts in the CRPF are competent and every member CRPF, irrespective of the cadre, has to clear training, running, exercise, and handling of firearms. This was found unfit to be basic training. It's rare for consideration or be drafted into other posts, other not competitive cannot be accepted. Either posts available with the it is submitted that all cadres require basic training. There are some the petitioner does not question the medical finding either in psychiatric department or the medical. It is not his case that petitioner suffering from AIDS stated to the government stated to have been public or that the findings are contradictory findings by other civilian activities. The only prayer for the court is that it by proper process. Constable CRPF had yet already attended that completed 3 months of training. He discharged because of the medical illness. He considered to be a harder for him to undergo basic training. It's to have been considered for appointment, or to have been considered for appointment in any other book which does not have competitive book. The respondents have categorically stated that all courts require are required to be require undergoing basic training. The discharge of the petitioner was at the time that it was basic training. The report of the medical specialist within the clearly that the whole case of like with a tendency to relapse where it's right. But the court reply the prayer made by the prayer for considering any other book, the CRPF, better duty cannot be that that basic training hopes prediction there to fail. However, the dismissal of the not to the right petitioner to apply for fresh election and appointment. He already job in take ready job and participate in the recruitment process by central state government. If his otherwise found suitable for participating in the selection process. Medical report given by the competent hospital, other specialty shall not operate as a bar to appear in research recruitment process that he is part public believe the department.
Yes, one humble prayer, that is instead of the word dismissed, it may carry a wrong message. Lost.
That
Yes. Hello.
what is needed to take. Yes.
Lordship, in this case, they have filed one additional affidavit, Lordship. So I want to reply. I may be granted for them.
Additional affidavit was filed on perusal of Lordship the answer script. Lordship, that certain anomalies have been found, certain numbers were not given as regards the.
He will have to respond if he wants to.
But his document, he cannot deny it. It's on.
No, he
have
says he
some
wants to
denial.
respond. I don't know whether he will deny or not. This is pursuant to the result. How much time?
4 weeks.
4 weeks.
Lordship, our office would be busy for conducting CC now, Lordship. CC 25 days.
He may be busy for anything. This is a pending writ petition.
At least
You have to find a way to handle it. You can't say that you are busy for the very purpose of constitution of your office is to hold the election process.
Lordship.
Is there anything else?
Yes,
to do?
Lordship, I understand, Lordship. But Lordship, what happened? On 9 and 10, Lordship, in 2000 June, Lordship, CC would be conducted all over Assam, Lordship. All staff, most of the staff, Lordship.
9 and 10 of what?
June, Lordship.
Huh?
June.
All right.
Thereafter, Lordship, we take some time to take instruction and to file affidavit. That's
The
why, Lordship.
affidavit will be filed by them, not by.
They're already there.
Yes.
Affidavit is filed on the basis of record. That's all you have to do. You have to, if you see, this is an affidavit where they say that on the basis of what is produced before us, these things are.
They are not expert to comment on the
No, expert or not. we
because
are
I will have to
not
seek the opinion from expert also, Lordship.
You get it from anywhere, but don't tell us that because of so-and-so exams, you need 4 weeks. Don't tell us that. This is your job to do it. These records are available with you. Get in touch with your expert. Tell them that this is in terms of a pending litigation.
Yes, Lordship. That's why
Are you addressing the court that we should wait until all your examinations and selections are?
I am just expressing my difficulty, Lordship.
No,
Yes.
that difficulty is overruled.
Okay.
File it within 2 weeks.
I'll try, Lordship.
File it if you want to file. This is not the way to say that the exams are held and you are going to require 4 weeks time to file your reply from your record. What will experts do now?
Lordship, we don't have any expert. We will have to requisition the expert.
We are asking you something. You have a question paper, you have a set of answers.
Yes, sir.
You have marked. Somebody has given a reply.
Yes.
Some examiner has accepted it to be correct, some examiner has accepted it to be correct. But the answers are on the basis of opinions of experts.
No, they have, it is their own assessment. They have filed additional affidavit. We will have to.
We pray for.
I am praying, Lordship. It is up to Lordship.
The council for external that the external affidavit has been filed. The basis of has been filed as certain anomalies have been noticed in the answer. In the
Markings, no mark.
markings allotted of record. The total the other end subset would like to file a reply affidavit. You would like to complete with the structure of the file the reply to advice. He prays for 4 weeks time. Considering that the petitioner before the court questioning mark allotted when he permit the doctor like that the liability fine within the 3 weeks as permitted and the matter be dismissed thereafter.
Obliged.
Yes.
Okay, may paper due.
8.
Before 28th. Can it be 16 or 18?
not 50. We are already on 30. Can give you a date on the last week. Or you have it in July.
Oh, sure, we have it in July. Wait for a date, Your Lordship, in July. I don't know.
It's not 16 July.
Not sure. Simply.
Maybe a lot. For compassionate appointment, my lord, it is pending for the district level of the Gulagat, my lord. Affidavit,
Not pending, Lordship.
my affidavit filed by the commandant, my lord, that is commandant stated that may not be considered. His father was working as constable 11 APBS.
Yes.
Lordship, in 2017, the compassionate family pension scheme was introduced in lieu of compassionate appointment. And the petitioner's father was died on 21. Therefore, he is not liable to get compassionate appointment. He received already compassionate family pension received by the petitioner already.
Good.
Therefore, it not maintained.
Either or. Either appointment or pension.
And 2017 notification that compassionate family pension scheme was abolished, introduced, and in lieu of compassionate family appointment. We have annexed in our affidavit. Lordship, that-
You have filed your affidavit.
Yes, Lordship. Says our affidavit respondent filed by respondent number 3. Commandant of 11.
Yes.
Number 5.
Yes.
Case number 5.
Roman 3. Compassionate family pension.
Government servant who died while in service or on after 1/4/2017 in lieu of compassionate appointment provided in 31/3/2017. And petitioner's father was died on 21. 15/7/21. Therefore, it is not a-
So pursuant to that, what happened? You said he has received,
Family pension, compassionate family pension receipt.
received.
Yes.
On which date? Have you stated in the affidavit?
It's not,
Then
but he is already meted.
in his reply,
But I can bring that instruction, but compassionate family pension getting, why, how can he?
you bring it,
Yes.
you bring that instruction first. Heard. Yes, have you received the pension?
I have not.
Let her bring it then.
Well, one thing, my one judgment will pass by Honorable Justice Michael. The pending cases prior to 3/4/2020.
Pending cases, but his case was not placed before the DLC because he is not eligible. for
Commandant,
compassionate
my lord
appointment.
himself, my lord, filed an affidavit of opposition.
Hmm?
Commandant himself filed the affidavit of opposition, my lord.
Yes.
Yes, here we have stated that. Paragraph 4 of our in paragraph 4 we have compassionate term has been of our
So we have seen what you have written there, but it doesn't say that he has received the compensation.
mentioned in
I mean, compassionate family pension.
yes. We have stated in our paragraph 4.
Please read.
It, 1 district for us, different was employee of the police battalion right now expired on 6/21 in department. According to that,
So that we have seen, but that he has received it, that is not there anywhere. You made a statement that he has already received the pension.
last time was 6 of this wife dead department, Devokanta Bora, Srimati Enimai Bora has been drawing compassionate family pension since the death of her husband, Devokanta Bora, as per government.
And where is that notification?
October 2007.
You have been receiving it. Mr. Talukdar.
Well,
How can you now claim for appointment? There is no averment in your reply affidavit.
I think I have enclosed this document of another justice.
You have that close, but you have to either admit or deny the submission made in para 4. There is a clear submission, and there is no reply to that.
Madam, Michael not yet, not mention any of that.
Hmm?
The pending
So
is,
first you have to answer how you are entitled to both. You can't get professional family pension as well as appointment. If you have already been receiving drawing family compassionate family pension since the death of our husband, then why are you claiming compassionate appointment? This compassionate family pension, when did your husband die?
father,
Father.
6/6/2001.
Father or husband?
Father. Oh, my father, my lord, I am the petitioner.
So who is Senimai Bora?
My mother.
So she is getting a pension, compassionate family pension. When did your father expire?
6/6/2001.
21.
21.
You have to clarify on this. So both of you, your mother is receiving, you are claiming for compassionate appointment. The purpose of compassionate appointment is to give you a hope for survival. Yes.
Step.
That's stated in our affidavit.
When is it?
To get the instruction that when the amount has been transferred, is this pension under the pension rule?
Yes.
The scheme that you are referring to is different,
Yes, compassionate family pension.
but there is already a family pension provision under the pension.
Yes.
So is the mother receiving that or under this scheme?
Under this scheme.
That is not clear. You get it. How much time would you require?
Letter filing.
Old method. You have to
Week?
take that 3 weeks or
3 weeks.
take it.
Affidavit in opposition filed by the respondent. The clear affirm that mother of the person has been receiving pensionable family pension under the government with effect of the death of the father. The government made public that in view of that and in view of whoever 10,000 the petitioner claim for pension governor, the other hand, right, whether the pension taken by the pension, or it after the OM dated 31st of October 2017. So the cabinet it takes for 3 weeks time to complete the inspection. They are not letting it be completed by the case of 3 weeks. 3 weeks. Yes.
One of the picture before lordship was working as a engineer. He was then deputy general manager, no? Deputy general manager in the Power Grid Corporation. And he realized that during his tenure, there were some anomalies created in the working, and a charge was leveled against him. The
Yes.
under Rule 25 of the for imposing measure penalties, the charges your lordship to find at page 26.
You're challenging the
Punishment imposed.
what is the punishment?
I mean compulsory retired from service.
And what is the ground for challenge?
There is no evidence, is my humble submission, my lord. The charges are imaginary, if I say so, in character.
Is there any a provision for an appeal?
Yes, appeal was filed before the authorities, my lord. That was also dismissed.
Further review or revision?
Review was also there. Review also not considered. The article of charges were you also will find at page 26. HK Bukon, Deputy General Manager, Man of Palipara substation was posted at Fulbari under NERSP project on November 16 to February 18. During his posting at Fulbari, he was looking after the construction work of Fulbari substation, and Srimoti Nidumoni Gogoi, wife of the petitioner, received rupees demand through her bank account, being Iman of the State Bank of India, Guwahati, from Sri Sutya Soikia, a labor contractor engaged by Nikon's executive agents at Fulbari station, or towards hiring charges of art excavator owned by her. Sri Pukon resorted to business with the working contractor under his control and misused his position for personal gain. And thus he failed to maintain absolute integrity, acted in a manner which was unbecoming of a public servant, misused his official posting or position, acted in a manner prejudicial to the interests of the company. Here it is alleged that she received some money from a labor contractor engaged by NIPCOM, and thereby they say that I resorted to business with the working contractor and his control, under his control, misuse of official, but she has not done any work below. It is true that she had two excavators, in our name, the purchase. And for that, my lord, I have made a small note, my lord, your here I have stated, and guess from his father stated that amount was paid to his wife towards higher charges and it is resulted to business to his wife and the working contractor. His wife has not done any work, my lord, in the company. She had the excavators. These excavators were leased out. She is not working through them. She leased out to one of the persons, and the contractor utilized the excavators through that contract, through that leased out lessee for the heavy work, for the construction work. There, here I have stated, it is also further stated around towards in the note I have given, Milan. It is, however, denied that the petitioner engaged his wife for any contract work. The contract work was by hiring JCBs belonging to wife was utilized in the work through the labor contractor only. The wife of the petitioner leased out the JCBs to Sirajul Islam at the monthly rent of rupees 1,30,000, and Sirajul Islam utilized the vehicles in the contract work through Suja Saikia from the later, namely Sirajul Islam. It is also in evidence that Suja Saikia paid the amount to the petitioner wife for utilization of the JCBs. In this regard, evidence of the labor contractor that I am referring to, you also may see that. Evidences of Suja Saikia and the labor contractor Miller.
Require examination of the report. You have the report.
But we are following, madam. Or you record with us, madam.
Let us take it up on a proper hearing. Require some extensive hearing if I.
Yeah, but it will be a full length here, will be necessary, madam. It is not the case for actually, madam.
But I thought this is sufficient.
Mr. Solian. Will require some hearing.
That's hearing will be, it will be full length.
Have it next week.
My lord.
Tuesday or Thursday.
My lord.
Right? On 5th.
Get it on 5th. No, 5th. Let it be on 10th, Miller. 10th of June.
10th.
10th of June.
10th, madam, and difficulties, madam. Let it be on 12th, madam. 13, madam.
No, 13. Either on Tuesday or a Thursday because you want a hearing that.
Hearing the madam.
Good.
17th. 17th. Okay. Let's have it on 17th. The matter will require extensive hearing. Council. Meetings are complete. The relevant reports stated to be available. The Commissioner. Are you relying on some authorities in support of your cases? Are you relying any judgments?
No.
None of the parties are relying on any judgment?
No, we'll have to,
So
madam.
you furnish an advance copy of the list of citations. To the
Oh,
court.
that will, that will.
You can do it by email also. Let the citation, let the authorities.
No.
post
Yeah, my lord,
title.
without entering into the merit of the where there is any perversity in the impugn order, my lord. That no point. He has not raised any point regarding to that, my lord.
We'll examine.
Only I will rely on that, Miller. Without evidence, it will be perverse then.
We'll examine that.
Right.
Matter parties will furnish its own. Ready? dated is 17th.
17th, my lord.
17th. Oh, yes. 17th of June.
June.